happened, my lords, and when these people were withdrawing, there were certain, my lords, liabilities which were not known. That is why people withdrew. I am saying I'm still higher bidder, my lords. I am ready to give 20 crores. It is 2 crores more today because this is, I was not invited. I would have given 2 crores plus.
Why did the court restrict the auction only to 3 parties? Who are you appearing for?
I appear for the secured creditor. What happened was first application was by the secured creditor for a private sale because sale was not happening at all in this. Therefore, initial application was for a private sale for 18 crores. Thereafter, the court again gave one more option for auction. Then this auction happened.
But the auction, why did the court restrict the auction only to 3 parties?
Because other 2 had gone. That time, this gentleman had withdrawn his EMD.
But the other person who was one of the 3 who participated, who was allowed to participate, he also had withdrawn his EMD. That's
later, my lords.
No, 1 month prior to me.
My lords,
1 month prior.
Just 1 month prior to him, that man had Agorik, no? Agorik.
Yes, ma'am.
My lords, in item 37.
29-1. I did on 29-2.
My lords may see page number 57 in item 37, annexure P5, that 16th May order.
Yes.
My lords, Sharp Steel, the main party, withdrew its offered bid as letter dated 6th May 2024.
No. My lords are not talking about Averick, my lords.
And my lords, in the same paragraph, page 59, where my learned friend is appearing, RSEC, and there was a joint lenders meeting in which this private party was approved as a buyer.
We will issue notice here. I think we'll issue notice here. We'll issue notice here. And who's the successful bidder? Is he a party here?
Yes, my lord. We have
Party.
You're not a... What's your client's name?
Square 4.
Square 4 Logistics. You're not implemented Square 4 Logistics?
They have not, but they're not a party. We are challenging the order. We have not completed.
Complete them.
May I will.
Also, the other secured creditor, X-ray, is a higher secured extent of 80. ASIL is here. They are only 30 crores. Aspect which is 80.
All right, you implead the other secured creditor as well as the successful bidder.
I will.
And we'll issue. And make it returnable in 2 weeks and dispose it off on Monday.
Lords, conveyance deed may not be, my lords, meanwhile.
Learned Counsel, go on, deposit them.
My lords, my grievance is at page 16, the 16th May order. The official liquidator was directed to release my claim by 31st of May 2024. Now, if my lords are staying the order, then my payment won't be released today.
You are the security agency, right?
I'm the security agency employed by the official liquidator.
We are not bothered about the security agency. Let him pay whatever are the dues of the security agency.
Let him make that deposit, my lord.
Yes. Sure. The grievance of the petitioner is that the High Court, by its order dated 30 April 2024, restricted the bidding to only 3 parties to the exclusion of the petitioner. And as a consequence, the petitioner was not allowed to bid. So its bid in the earlier round was in the amount of rupees
23 crores plus.
23.44 crores. Eventually, the bid which has been accepted is stated to be in the amount of rupees 18.13 crores. Full stop. The successful bidder, Foursquare
Logistic Park, man, Private Limited.
Foursquare Logistics Private Limited.
Private Limited.
Please give the name. Has appeared and has appeared through counsel in these proceedings. Full stop. We direct. Full stop. Notice shall issue. Liberty to implead. Liberty to amend the specially petition so as to implead Foursquare Logistics and the
ASREC.
and ASREC, who is the other secured creditor as a party to these proceedings. Full stop. Notice shall issue to the newly impleaded parties. Full stop. The proceedings shall now be returnable. Thus, the permitted in addition. List on kar do after 2 weeks on a Monday. In the meantime, we direct that no conveyance deed shall be executed. That no deed of conveyance shall be executed. However, the above order shall be conditional on the petitioner depositing an amount of rupees 20 crores.
My lords, I'll give over a period of time, my lords. 3 weeks, because they are being given, my lords, immediately.
So we'll give you 2 weeks time. 3 weeks. All right. Notice shall the petitioner shall deposit an amount of rupees 20 crores before the registry of the High Court of Calcutta and produce proof before the registry of this court in regard to the deposit so made. Full stop. Failing deposit, the petitioner shall lose the benefit of this order and the specially petition shall be dismissed without further reference to the court.
Only thing is there are 2 secured creditors. My lord, we will include both. My lords have said one.
ASREC, all right. What we'll do is
ASREC and ARCIL.
the other one is RCIL is already a party. So the other one. And we keep it. If he deposits 20 crores, then we are giving him notice and keeping it after 3 weeks. If he doesn't, let us first see the color of money and deposit before the Calcutta High Court.
This order shall not come in the way of my payment. That is the only.
We have not said that. We are not concerned with the security expenses. Yes. You didn't deposit the mandatory 50%.
Because the challenge was in the revision.
No, but there is a I got your point that your challenge is about the valuation.
Upset price.
But right.
Yes.
But notwithstanding that, there is a recovery certificate against you.
Yes, recovery certificate.
You can't get over this requirement under section 154(2)(a) of the Maharashtra Cooperative Societies Act by saying
May I read the section, my lord, at page 19? May I read the section, my lord, at page 19 for a moment?
Says against a recovery certificate.
Against recovery, 10.
But
yes.
you are tacitly impugning the recovery certificate also, because otherwise, if we accept your point, then people will merrily start challenging all intermediate stages of the proceeding.
I can't pay, therefore recovery certificate is issued against me. I'm suffering the recovery certificate, option proceedings have been initiated. Only thing is, my lord, even if
How much is the amount? How much is the amount of the recovery certificate?
Recovery certificate is 17 lakhs and 11 lakhs, my lord. And one thing I must point out, 2016.
You have to deposit that 50%. Otherwise, these are all dues of a financial institution.
Please, my lord, here is man, my lord. This is the only agricultural land. My lord, 2016.
What do you have to say?
I am appearing on a caveat for the bank, my lord. My lord,
Yes.
So far, first his legal aspect is concerned that he has not deposited, he is not entitled. That is one aspect.
But he says
Second
that he
aspect about the valuation of the property.
No, he says that the requirement of deposit applies only where he is challenging the recovery certificate. That's the language of 154. And I'm not challenging the recovery certificate. What do you have to say to that point?
But my lord, ultimately, auction is in consequences of the recovery certificate.
He is right, actually, because
Then you can. May I read out the language, my lord? May I just point out, so far as language, there is a clear distinction. 2A was introduced subsequently by of amendment in 2000, my lord. Before that, my lord, page 19.
But if we accept this, what will happen is that ultimately, what is your grievance? Your grievance is in regard to the recovery certificate.
No, my lord, may I point out, recovery certificate, I don't have money, I didn't file a revision, so far as the recovery certificate is concerned, that is final, so far as I'm suffering that. But then even if I'm a defaulter, my lord, I have a right that my property should fetch the best possible price. Here, what is happening, my lord, 3 times that upset price is fixed. Twice, on the similar ground, the revision court has accepted my plea that it is being sought to be disposed of for a throwaway price. That is my specific case. And this is my only agricultural land. Not Article 300A, and even if I consider that I'm a
What is
defaulter.
to be done? 3 times the property has been put up for sale and
Yes.
there's no buyers. This happens in all these auction sales.
No, the upset price was set aside at my instance, but court has specifically accepted the fact that it is not the market value of the property. But bank also, as your lordships have repeated,
How much have they fixed the price, upset price? Sir?
But now, third time, it was fixed at 37 lakh rupees. And I must point out to my lord, 2016. 2016, I purchased the property. The sale deed is on record. I purchased it for 41 lakh rupees. After 8 years, the property is bound to appreciate. And not depreciate is what's my specific.
No, but the point is that, if it had appreciated, somebody would purchase the property at the auction. The fact that it is not being sold,
That's 2000.
therefore they have to reduce the upset price then.
Not to this extent, and my
3 auctions, it has not been sold. Therefore, they have to reduce the.
My lord, I must convey that on 6th auction had happened and the highest bidder was of about 45 lakhs and the bid has been accepted for the 45 lakhs. The government valuation that DDR has rightly considered, government valuation is about 20 lakhs 87,000 and the market value was considered as 37 lakh 89,500. When DDR passed that order, the 45 days was granted to him that you please bring the purchaser that on your price. He failed to do that. So ultimately, my lord, this is the best price which has been fetched right now.
Not in.
May I just point out?
No, sorry, it will not. Shall dismissed, yes. Thank you. Thank you.
I am obliged. My lord,
Item 15, yes.
I have filed a caveat in this matter, but I couldn't file my appearance. Physical appearance.
Give us slip to him.
I am your obliged.
In this.
Sir, one more classical PIL by you. Writ petition for a direction to the Union of India to take action against cyber terrorism.
No effective law because we are all are affected.
The only thing which I can say is on all Mondays and Fridays when your petitions come up before us, we get some comic relief, So that's all I can say.
That office report got corrected. But separate issue, this is cyber terrorism. We all are affected by this. AIMS site of AIMS was hacked, Some strict provisions. That's all.
All right. This is not part of the judicial domain. Government is, you have laws today.
Response only,
Thank you.
And I'm withdrawing this.
Yes. Withdrawn.
Orders are not being complied with.
We'll issue notice.
They only want 18 years, 27 years.
Yes. And we'll, this. To notice, returnable on, keep it after 2 weeks. Personal presence is dispensed with at this stage. Liberty to serve Ms. Garima Prasad, learned AAG, Standing Counsel for the State of Uttar Pradesh. I told him give a specified date. Maybe another one. The rights to dignity of. Police officer to wherever there are legal provisions, those legal provisions exist. But for us to issue, how do we monitor those directions then? You want the appointment of women doctors in district government hospitals to conduct medical examinations of sexual assault victims. It's also a question of availability of doctors, not just a question of issuing general directions. The issue is of availability in that particular district. And So far as investigating officers, etc. are concerned, you have provisions of the law which are in place. That's a matter of implementation.
It's just one submission. My lords, in some offences, the accused, the victim's examination has to be conducted by a woman doctor as per my lords, subclause 2 of section 27 of POCSO, my lords. My lords, just juxtaposing that, my lords, I am saying especially in cases of a women public prosecutor, if they could be appointed in cases of sexual assault, my lords, if the PIL could be limited to this aspect, my lords.
But how can we say that in a case involving gender violence, only a woman public prosecutor should be appointed? Why should we presume that, anybody other than a woman public prosecutor will not be effective in rendering duties? There's no such presumption for us.
Plus, there's another aspect involved in this PIL that supposedly there's an FIR registered today. Subsequently, the sections involving rape or sexual assault get involved. Ultimately, then there is no provision for the FIR to be struck down from the portal, my lords. Because ultimately, if there is an FIR involving section 376, it should not be there on the portal. But sometimes in cases, these sections get involved at a later stage.
Mr. Chaudhary, you do this. You bring up specific case before us with the specific grievance, we'll deal with it. And then we can see what general directions to issue.
Just grant me 2 weeks time. I'll come up with specific cases.
Come up with a specific case. We'll allow you to withdraw it at this stage. Okay? At this stage, withdraw.
Item 18, it's the same petitioner.
Same here also. Amend the practice and procedure rules.
Well, it's because the victim does not get a right otherwise unless he is informed, my lords. He cannot exercise his rights. Though the Jagjeet Singh judgment provides that he has an unbridled right, but my lords, unless he has the knowledge of that right, how will he exercise that right? My lords, in CRPC, there is no provision of a caveat. In Supreme Court, though we can file a caveat, but that has to be renewed every 3 months.
You must always ensure the victory.
And my lords may permit me to withdraw, my lords. Much obliged.
Item 19, your lordships may kindly see I appear for the petitioner.
Against interim orders of the High Court.
No, my lord, this is a case where there is a moratorium issued and the writ for recovery is going on, my lord. Section 14(1)(a) is clear, shall not be instituted.
Proceeding is pending before the High Court?
Yes, ma'am.
Yes, my lord. And
Point it out to the High Court, Mr. Tripathi.
Sorry, my lord.
Point it out to the High Court, Mr.
We
Tripathi.
pointed it out. Please see what the High Court says at my lord's page 21, para 16. Please see that, my lord. On the same day, there was a moratorium. Mr. Doctor had appeared for us. He pointed it out to the High Court. The High Court, my lord, says in para 16, page 21, we accordingly direct that the defaulting company and the IRP, my lord, defaulting company, albeit not to be told that it is facing insolvency proceedings, the usual mantra. That's how it has been dealt with. As also its subsidiaries in their own wisdom to take a reasonable approach and make an endeavor to resolve the issue. Well, this was pointed out. Our solicitor's letter is there, which is in the additional document, my lord, at page 15.
Oh, yes, what is the position?
Manoj, may I just give me 2 minutes? Manoj, this is a matter, and I'll come to the insolvency issue in a second. 5,000 crores is owed to NCD went all over the country trying to attach their writ petitions filed, dismissed by the High Court. They came in an SLP, dismissed by this court. We went all over. No one was even attaching their properties all over. Ultimately, we had to file a writ petition in the Bombay High Court because even the authorities in Maharashtra weren't cooperating. And every account we went to, they withdrew and had all 1 paisa or 20 rupees left in it. Those are the standard figures in every account. Ultimately, the Bombay High Court came down heavily on the authorities and said, how can you let public money go in the manner that you are? Finally, the 3 orders that my learned friend are referring to, what do they say? The moment you bring it to their notice, the court will not proceed with the company. These are pertaining to subsidiaries. The insolvency is not on with the subsidiaries. These are places where you want 99%, 100% of the subsidiaries, and new contracts are being given to you. The impugned orders at one place say that how can public authorities give contracts to parties who in collusion are defrauding parties to the tune of 5,000 crores? And what does that learned friend? What he doesn't point out is the first impugned order that he refers to is dated 21st/3/2024, on which date the court directed the subsidiaries to place on record only their details of assets. On that day, no insolvency order passed. Insolvency order, the admission order comes on 28th of March 2024. On that date, I am instructed to say a parallel proceeding happens in the High Court. They do not point out to the High Court that it's an admitted petition. Under section 7 or 9, they only say we are facing CRP procedures. Then
No, that's not true.
On 11/4/2024, that is a day before the hearing on 12/4/2024, they file an IA annexing the order. We don't even know whether that IA was placed before the court or not. So what my Lord the Chief Justice said right in the beginning, if the court proceeds with the matter pertaining to the corporate debtor, despite the order being pointed out to them, bring an application on record, point out to them there's an admitted CRP, you can't proceed against the corporate debtor. That's one part. But your lordships against pre-interim order are being told that the High Court should not proceed against the subsidiaries. All subsidiaries where you're diverting money, all subsidiaries where contracts are being awarded, we should not proceed. The High Court consciously lifted the corporate way. This is a classic case, my lords, where we have gone all over recover a penny against this party where 5,000 crores is court. The Bombay High Court came down heavily on the authorities, and that's when the attachment started. Now, whether court admission will carry on vacated, that's for the NCLT to decide, or for the High Court to decide. What is so extraordinary that this court should today exercise its jurisdiction and intervene in a matter like this, my lord, and especially in mind, if you point out to the High Court there is an admission order today, and the High Court proceeds against the corporate debtor, then maybe you have a cause of action. You've come interim orders in this matter, wherein, as I pointed out, against the first interim order, there is no order. On the second order, you point out we are facing it, don't point out it's admitted. And what did that order say? It just told them to disclose assets in the matter. Their biggest concern is that these attachments which have been made and which are being made against the subsidiary companies are the only source through which a public authority can today recover some amount of public money at all. So they want the entire thing to be brought to a standstill and consume the whole issue.
Alan, my friend is plainly wrong. He has moved a Form C before the Malod's IRP. This is as a financial creditor, the banks have come. They have come as an operational creditor. They are doing all this, Malod, so that they can jump over.
Is it correct?
I am the IRP.
Taken are not against the corporate debtor, but against the subsidiaries.
No, my lord. I'm sorry, my friend is wrong. The shareholding of the company, which is the corporate debtor, is the asset which is sought to be attached. Let that be clear, my lord, that no part of the asset of the corporate debtor can be dealt with. What they are seeking to do, please see the prayer in the writ petition, which my friend doesn't point out to your lordship. The prayer in the writ petition is that please proceed against the
insolvency proceeding.
That writ
Is there the subject matter, but a large part.
I'm sorry, my lord, that writ has to go. Please see the prayer at page 424. And my friend, and this 5,000 crore bogey, it is their ipse dixie. I am, my lord, the toll collector of MCD. Lordship knows MCD is one of the most dubious institutions in the country, with thousands of crores, my lord, going the wrong way. I am a toll collector, and they have raised a demand and they have gone to execute it without it being adjudicated.
Just kindly see page 4 of the order. It says category about the corporate debtor, my lords. The order of the High Court.
But the High Court is seized with the matter. Why should we entertain it at this stage? I mean,
reason-
these are-
But the writ can't go on without the
they are
writ
public
petition.
dues of 5,000 crores.
No, my lord, I'm sorry. No, let my friend show the basis of the dues of 5,000 crores, their own assessment.
My lords, I
Not
have
the
the
adjudication.
report today. I have
My lord, that's not been adjudicated. MCD of Delhi, your lordship knows it has thousands of people on the rolls who don't exist. Sorry, my lord.
I'm sorry.
Now, my lord, there is no adjudication of 5,000 crores. This, I am a toll collector. From where will I, my lord, where is the question of 5,000 crores? That's not the recovery of toll. Is my friend saying that there is a toll recovery of 5,000 per annum for MCD? What is my friend saying? Lord, this is all ipsetic. See, some officer in MCD thought it's a great idea on their claim untested. And that is what the IRP has asked them when they, and my lord, they
Now,
begin.
this order
Yes, my lord.
please stands over the proceedings to 12th of April 24.
That's right.
What is
Well,
the
but-
operative direction in this order?
Yes, please see the previous order of 21st March, which has not been, my lord, stayed. Please see what it says.
And next date is July 15th.
Or,
My lord,
Lord,
first order of.
my learned friend, just let me finish that in a moment, my
You are
lord.
directed to place on record details and documents which provide for information regarding.
No, my lord,
NEP's
please see
assets.
para 7, which my friend is not
Order
reading.
talks
One
about.
second, this order which Mr. Tripathi was relying upon, para 16, we accordingly direct the defaulting company
Yes.
not to be told that it is facing insolvency proceedings, the usual mantra. Also, its subsidiaries in their wisdom to take a reasonable approach and make an endeavor to resolve the issues. We shall hear the parties on the adjourned date of hearing. We accordingly adjourn the proceedings to 12th of April 2024.
After the, see page 4.
What are you aggrieved by in this order then?
Well, I am aggrieved by read with page 4, para 7, which is a direction.
All right, which is the order you are challenging, Mr. Tripathi?
Both of them. Both of them.
So this
Is-
order now, what is the part which affects you?
My lord, the writ, my lord, the law is as laid down by your lordship.
Tell us what part of this order affects you?
My lord, the part of the order which affects me is that no proceeding, whether to participate actively or otherwise, constructively or otherwise, can lie once, my lord, there is a moratorium against me.
Where is a restraint by the High Court contrary to law here?
Yes, please read it with para 7 at page 4, which I have also challenged. Please see that only for a moment.
All right.
Page
just
4,
one second.
para 7.
We'll see that.
Yes, grateful. Para 7. In the circumstances, we are of the opinion that Tehsildar needs to take all steps to advance recoveries as law requires him to do. Now, my lord, this part, it has to be made clear that this can't happen. That is not clear. Tehsildar is proceeding.
Were you before the court when this order was passed on the when this order was passed by the High
Well,
Court?
yes, I was. This order was prior to, my lord, the moratorium.
Oh,
Therefore,
prior to the moratorium.
that's right. So it can't now continue. That's all what I'm saying.
When the
Yes.
court passed this order on
Yes.
what is the date of this? 21st of March.
21st. Yes, my
The
lord.
High Court was perfectly justified in passing that order because there was no moratorium as on the date of this order.
Let's assume so, though according to us, no, because the amount is not admitted.
Moratorium, according to you, comes
Yes.
into being later,
On 28th.
28.
On that day, my lord, this order should have been stopped, stayed. This order is continuing, the Tehsildar is
But the High
proceeding.
Court is seized with the matter. You argue whatever you want to show.
Lord, I have pointed it out to the High Court. High Court says you are not to be told
There's
that.
all window, there's all
Lord,
chat
kindly
box
page-
to go before
No,
the High
Lord,
Court.
I am in IRP. My lord, I'm so sorry.
These are all
Please
nothing
look
but
at the other
Kindly see
half.
page 22.
Lord, please see.
defeat, public authorities.
Please see page 20.
No, my lords, kindly see what has happened here is
Matter coming up before the High Court now.
It's 12.
Pursue your
there is no
remedies.
fixed date.
Only 1 second.
Would your lordship say?
Tripathi is there, not two people arguing. Yes.
I'm sorry, but he appears for the company. My lord, I appear for the IRP. I am, my lord, purely an IRP. I look
He
after.
appears for the IRP.
I'm together, my lord.
Very well. I'm so sorry. I heard his appearance. No, of course, only one person. I quite see that. Audiatum partum can't be taken to that level, my lord. I see that. I apologize for the confusion.
Why should we interfere at this stage?
No, my lord, may I
Not
only
a
say
matter
this.
for us to interfere at this
Your
stage.
lordships may make, my lord, kindly see, I am, my lord, answerable to the
You
commission.
point out the provisions of law to the High Court. The matter is pending before the High Court. The High Court will deal.
If your lordships, my lord,
If
at
you
least
pass an order
directed.
contrary to law, then come here.
And I tell you,
I appreciate that. But may I say this, my lord?
get some.
Because may I say
That's
this?
why now we are proceeding again.
After
so that we
28th
can't
of
get
March,
against
because after 28th of March, the matter has not come up. Would your lordships please say that on mentioning it will be taken?
No, not at all. We're not interfering.
Grateful.
Yes, item
Very
20.
Wait, please, minutes. Millet's a partnership firm that got dissolved long back. And now an erstwhile partner who got his share, everything settled to registered documents, comes back and says there was an income tax right vis-a-vis one of the partners. And then it came to light that he purchased some extra property. That's why everything should be reopened.
What was settled, Mr. Shishadri, what was settled before the Lok Adalat
Yes, ma'am.
was relating to a suit for specific performance.
Yes, ma'am.
Which was filed by the petitioner's MD of Sama Construction.
Yes, ma'am.
Now,
He takes advantage of that document.
you can always raise all defenses under section 16.
May I submit one thing?
Yes.
Gross abuse of process, in the sense, once they've all retired and they've just left Millets, now they've been drawn back into this cauldron of litigation for no reason, just because he wanted to have an extra pound of flesh. There could have been other ways. Millets, my lords may kindly see Millets. The reason he has given, he says that it was an antedated document which was executed in 2015 as if it had been executed in 2007. He willingly, according to him, subscribed to that one.
There's a settlement or otherwise will be looked into by the arbitrator.
My lords may kindly see one look at page 11, Millets.
That's my
Where the plea has been taken, the document is void. Not even a sentence should be binding on either any of the parties to that one. Still he says that I should invoke the arbitration.
You can still argue that before the arbitrator.
Millets.
Whether the document is void or otherwise.
When the
will be
document has
decided
been robbed of its validity because of, they say that a fabricated one, Millets.
Not the case for us to interfere.
And Millets, in fact, through
They were
registered
appointed an arbitrator,
document, he
correct?
got his
High Court-
share.
The High Court under Section 11 could not have gone into these issues, Mr. Shirali.
Precisely, Millets. And my lords may kindly have a look at page
Therefore,
11.
they've appointed an arbitrator. You argue whatever you want to before the arbitrator. Thank you. Dismissed. Yes.
May I just plead, Millets? May I plead one thing, Millets?
Yes.
May I plead, Millets, since your lordships, it's fallen from your lordships, please allow us to have that as a preliminary issue. And then, if at all it survives, then I could face it. Otherwise, it has to be shut out.
What is your, who are you appearing for?
It's corrected, madam.
Slightly different arguments. Clarification from your lordships may suffice, Manoj. Your lordships be kind enough to see the arbitration clause, Manoj, which is at.
What is your contention?
Manoj, my contention is this, Manoj, that the arbitration clause is limited. There are two agreements, 2007 and 2015. Arbitration clause is only the first agreement, but admittedly there is no arbitration clause in the second agreement.
Raise that under Section 7.
That's all,
Section
that's
16.
all that I'm saying. The prayer that has been allowed is reference of disputes under both agreements.
But you can
Yes,
raise.
please clarify that.
Why do we have to say that? You have a remedy under Section 16. Why should we clarify something which is implicit in the act?
Please see the order of reference.
You can look. Parties know what they can raise under Section 16. We are not going to give any such.
Millets will not be
Raise
troubling your
whatever
lordships.
you want.
Millets will not be
Thank you.
troubling.
Next
Please
matter.
kindly observe, Millets.
Shadri, thank you.
If at all we raise Millets, let it be a preliminary issue, so that
We'll
you
not
will
do
not go
anything
through
on
the
that.
whole hog of the
Sorry.
litigation.
So arbitration gets absolutely goes for a toss. Yes.
Millets. In the absence of Millets, my instruction is that Millets. May I just plead, Millets? Millets on instructions, millets permit me to withdraw that. That's what they
You want to withdraw also?
It's
All
the same, must suffer the same.
Otherwise, millets, it will have the stigma of dismissal.
All right.
You only request that.
Item 21, then 21, yes.
This comes up after notice. This is a petition under section 7 of the Arbitration Act.
Yes.
My lord, last time on 14th of August when the matter came up, your lordship asked me to give 3 names of retired judges. My lord, I gave 3 names. One was Justice K.L. Vadne, Justice Davre and Justice Sal. On 18th of, it was listed on 18th of August for that purpose only. On that day, my friend sought time and therefore your lordship had imposed a cost of 1 lakh on 18th of August. Now, my lord, out of these 3, what happens in between is when I file a petition before your lordship, they appoint one lawyer unilaterally without my consent and get an award passed in their favor. Your lordship indicated to them this can't sustain. You choose one amongst retired judges or you choose any one retired judge.
Now,
and
whom do you want to go to arbitration?
Can I just make 2 respectful submissions? The first, in terms of, I wasn't there at the last hearing, so I don't know what transpired. So for my learned friend to say that, well, everything, I don't have to argue anything and we're only looking at appointment of an arbitrator, effectively means, that I have nothing to say. But if your lordships looks at the dates, please see what has happened. I wrote to them and I sent them a notice of arbitration. They have never issued a notice of arbitration on their own. So whether they have a section 11 that's maintainable without a notice of arbitration is very questionable in light of your lordship's recent judgment, which your lordship pronounced in April. Second, in my notice of arbitration, I named an arbitrator. They go to the Bombay High Court, after which they come here. They withdraw the SLP here saying we'll file a section 11. They take 14 months to cure that defect in the section 11, refuse to participate before that arbitrator, who awards my claim. What is the claim? They took 2.5 crores from me, my money, did not supply a single machinery to me for 5 years, agreed to give the money back to me. When they didn't give it back to me is when I invoked arbitration. And now they don't have a dispute. That's why they don't even have a section 21 notice. So how does the section 11 lie at this stage? Without a section 21 notice, how
do you issue a notice under section 21?
They've never done it.
Mr. Chaudhary.
what happens is this, my lord.
He issued a notice for arbitration to you on 23rd of December 2019. Sorry. He actually issued a notice on 3rd of April 2019. Yes. They invoked arbitration. Am I right?
That's correct. On 23rd of December.
You object to that on 16th of April 2019. Yes. And then they, on 23rd of December 19, they say that they are appointing that Shivom Garg.
That's correct.
That is wrong. You couldn't have unilaterally appointed.
But they filed a 34.
But look at the complete fraud on the process. You just unilaterally appoint an arbitrator.
I didn't unilaterally. I said, if you don't...
have to move with section 11.
That's what.
And
if they have a claim, they should come to the court.
Please see the predicament I am in.
Mr. Diwan, look, Mr. Diwan, you're from Mozambique?
Yes, that's correct.
Why don't you?
I'm the buyer. I'm the one who's paid.
Why don't you both agree to an arbitrator? As we last time said, you both agree to an arbitrator who's a retired district judge, a retired high court judge, a retired some council here, and we'll send it to a council. You tell us who you want to go. Because it's not a large game. It's what, 2.5 crores.
There's only one very interesting point that comes.
2.5 crores, right?
3.5 crores now they get.
The quantum is not very much. I accept that.
So any of these retired judges, I gave 3 names. They give any name, I'll choose one.
The quantum isn't much, and I don't want to detain your lordships beyond a point.
I
have an award in my favor.
There's no 34. It's only a paper award. I mean, that's
telling me.
How could you have just unilaterally appointed?
Look, I didn't unilaterally appoint. I said
you had to move a section 11.
Look, I could have. I'm not saying
you had. That's the only remedy. You can't say I'll appoint whoever I want and he'll be a sole arbitrator.
I said if you don't object, it will be assumed that you agree to the other.
Not the law. You have to move the court under 11. So now tell us. That's why now it's come up after what? Nearly 11 months.
That was kept specifically for this purpose.
Now tell us, you need not take one of the 3 arbitrators they have named. You tell us whom should we appoint. Where is the arbitration to take place?
Pune. And he appoints someone here.
Plus, can we get a lawyer from this court? Plus, your lordships may appoint a lawyer from this court.
from our court or?
Please point out.
I have no problem.
This court. Well, it's only one aspect. Your Lordship may clarify, because I actually technically have an award in my favor, which has not been challenged. I might have to raise it again, because otherwise, all disputes.
We'll just say, bearing in mind the arbitration agreement between the parties, bearing in mind the arbitration agreement between the parties, Ms. Archana Pathak Dave, Senior Counsel, is appointed as sole arbitrator to adjudicate upon all the claims and differences. Full stop. The arbitrator shall fix her fees in consultation with the parties.
Deeply grateful.
The
I am so.
arbitration petition is accordingly disposed of.
Item 22.
I am so.
This is the matter about the uniform.
Yes, yes. I remember this, the matter came up last on 7th of March, I think, when it was mentioned. Before that, 9th of January.
9th of January.
Now, what is the position, Ms. Bhatti?
Lordship would recall what my lords had asked us was to give a roadmap.
For the future, yeah.
So the suggestion was, my lords, from our side, that the agreement can have Part A clauses which would be there, and Part B would be incorporated by the states depending upon the local laws, which would not be inconsistent with RERA. So we had accordingly prepared and we had given for Lordship's consideration. Lordship had then directed us that let all the states give their responses and then a final Part A clause can be placed. So this third status report, my lords, after considering all the suggestions from the states, the final Part A clauses have been placed for your Lordship's consideration. This was filed on 5th of July, my lords. Your Lordship would file in your Lordship's file at page 2665. The additional.
The additional, right?
Three.
Six, three.
6-3.
5 actually.
Lordship's E-file, it would be serial number 34, the last one.
It appears that this, your last report, can we keep it tomorrow or day after, whenever you want, because we'll have them uploaded because we have not seen it.
Lordship,
so now you have prepared model builder buyer agreement.
My lord.
Part A is the general agreement, which is consistent with the RERA.
Lordship.
Part B will be the state-specific conditions. For instance, Maharashtra, the Slum Rehabilitation Authority, so on and so forth.
Even Haryana,
Now,
etc. They would.
Has it been circulated to all the states?
Responses have been received. We have actually looked into each of those responses. We have given a table also as our first annexure, giving the comments and accordingly incorporating those suggestions in the Part A clauses.
Oh, I see. Can we just do this, maybe take it up tomorrow or day after, because we have not seen the last, and all three of us, our brief ends at page 2663, 2665. Mr. Mishra, what do you have to say?
Marcus has done a human job. Problem state of Haryana, that's a very critical state of the Lordships are aware, because maximum development is taking place there. So there, I'm hearing for and the Lordship will kindly permit us. But our reservations have not been taken into account at all, with the greatest respect to the learned amicus. Number one. While other states, he is given much greater weightage. That's number one. Number two, there are unique features as far as state of Haryana is concerned, where your lordships have now laid down the law over the past 3-4 years by the Chief Justice himself. For instance, very simple, when should compensation start kicking off? On the date of valid offer of possession, or on the date when possession is actually handed over? Your lordships have held. The builder, the onus is on the builder to give a valid offer of possession after due OC is received. But when the buyer comes to take possession, is up to him. I have no control over that. So, here the onus is sought to be shifted. When the buyer takes possession, the builder must continue to pay. The buyer will never come to take possession, because he is getting 9% interest or 7% interest here. So he will wait for 2 years, 3 years, 4 years. So it will, and he will, under RERA, he will get 10% interest.
What is to be done now if there are any subsisting objections about
the other problem is,
yes.
Lord, may I just put this for one?
What do we, you are appealing for the state of Maharashtra? Or?
I would like to take instruction on this note, Lord, because I don't find anything about Maharashtra. I'll just take instruction. 1 week if the Lordship keeps.
How do we now deal with these, whatever remaining objections are there, Ms. Bhatti and Mr. Baruka, Mr. Upadhyay, what do we do about these kind of objections now which have been raised?
My Lord, there are 3 states. One is state of Nagaland,
Yes.
which notes that because of Article 371 capital A, RERA would not apply at all. Now, I believe I had a discussion with the ministry officials. They are actually in touch with the state government and trying to sort out that issue. That may not really come on way. And also, I believe, Malas, another petition is pending consideration before your Lordship, where also the RERA implementation as an issue itself is continuing in terms of the entire country. Secondly, Malas, state of Tamil Nadu has indicated that they have actually got 2 agreements instead of 1. So we have indicated, Malas, in the report that 2 agreements cannot really be done. It should be 1 because anyway, it's across the country, it's a single agreement, and that's the scheme of the RERA. So as Haryana is concerned, I had the occasion of sitting with my learned senior friend with respect to the matter. But it's there, to my understanding, it's really about certain local laws like the Haryana Ownership Apartments Act, etc., where they seem to be slightly in conflict. Now, they have placed on record, and I will show the affidavit, a certain order of the government of Haryana saying that because of these conflicts, they have issued a letter internally that the local laws would apply as opposed to RERA. And in the latest Haryana affidavit, a response to these clauses, they have said that in the rules, they have amended the rules in a way so that they are able to adjust this conflict. Only my submission, my lords, and I will probably place your lordship's West Bengal judgment also. It is RERA which needs to be implemented. In case there is a conflict between state and center, probably the state would have to in some way give way to that. So that's a Haryana probably is an area which probably your lordship would want to hear. Otherwise, my lords, in my submission, otherwise the entire states, all the entire country should not hear.
My colleague, so I'm grateful.
The Union Ministry has worked extensively. So this but Malas, it is consultation and legwork of the ministry itself.
So perhaps what we do is,
My Lord, as far as
3 days, let's read their reporting. We'll also see the report of the amicus. We will hear whatever objections say CRIDAI has, and in the meantime, you take instructions for the state of Maharashtra. And if something remains, we will deal with it and otherwise resolve it. Because now we'll take that on the record. Prima facie, we should take these agreements on the record and say that all states will have to implement this, because there has to be some uniformity otherwise.
My Lord, as far as Nagaland is concerned,
Nagaland, they are looking into it. They are in touch with the Chief Secretary, they said.
in fact, we want to refer the matter in terms of the Constitution to a committee which is constituted by the Legislative Assembly of Nagaland, specifically for looking into whether the laws are in consonance with Article 371.
We can, Nagaland specific issue, we can keep aside a little bit. Because, we need not allow the Nagaland issue to sort of, because this is vital for the entire country. Otherwise, buyers all over the country are being defrauded by builders. Now, if we have one model agreement, at least there'll be some guarantee that, there is some uniformity in what builders impose on buyers. Nagaland, I quite see, this is the Article 371A issue. We'll keep it slightly out of the picture for the present. And you also take instructions on what is the way forward insofar as Nagaland is concerned.
Meeting is happening today. RERA itself applicability. So when it becomes applicable, it will be done.
So we can create an exception today for Nagaland. That's all.
Discuss my friend, and he agree with me. The basic thing, Mala, we are constructing. First thing, we should be in the agreement, Mala. What will the strength, strength of the foundation?
That's all right. Therefore, now the model agreement covers these aspects.
No, it is.
So, my lords, there is a Schedule D which says specifications, amenities, etc.
Okay.
So my understanding, that is where it should fall. It cannot really be otherwise.
It has to be in specifications.
Yes, Mala. Otherwise,
we'll keep it on Thursday. We'll hear you for 5 minutes.
The column status is M20 or M25, M30.
All right. We'll look at it at that aspect.
May I just make a request? the Lordship may consider, kindly have it on next Wednesday. Thursday, I'm somewhere.
Not this Thursday. All right. Monday?
Next Monday.
Or
Wednesday,
Friday?
actually, it's a family marriage, so that's why I'm.
Keep it next Friday then?
I'm so grateful.
We'll keep it Friday week then. Friday week. Mr. Bharuka, just make sure that it is the report which has been prepared. The report which has been prepared by Mr. Devashish Bharuka, Learned Senior Counsel, in consultation with the Ministry of Housing and Urban Development, the Union Ministry of Housing and Urban Development, has not been scanned and prepared and placed in the record. The registry shall ensure that this is done by the next date of listing. Full stop. If any counsel appearing in the matter who desires digital copies of the report of the amicus curiae shall be at liberty to obtain copies from the registry. List on, we'll keep it Friday week so that we can dispose it of it.
I was able to actually download this from the e-filing website, so probably it's there available on the.
It's there, but somehow it's not being provided to us. All right.
My Lord, may mention also, as far as state of Nagaland is concerned, it can be taken up.
Today the meeting is being held, so that we are not saying anything about Nagaland for the reason that Ms. Bhatti said today a meeting is being held.
No, I am conscious of it. I am a member of that committee of the.
Tell us next time. We are not passing any order for implementation today. So there's no order for implementation by any state or UT today. So let's apprise us on the next date what happens about the state of Nagaland.
The item 23 also, there is an error on our part. We have not filed that affidavit, my lords. That affidavit, we assumed it was filed. It's notarized in February. The accessibility guidelines have been framed after the committee was constituted. We reported, your lordships may consider having it next week.
All right.
We'll see that it's filed, my lords.
This was only viewed. Wait and we'll keep it next week.
Please.
24.
Grateful.
24.
Please. This service is complete, my lord.
Claim is about US dollars 2 lakhs, no, 200,000 US dollars.
Yes.
Which claim?
And on our part, we suggested one arbitrator, my lord, at page 71. This is in Kerala, my lord, Tiruvalla. That is agreed, my lord. That is page 46. Page 46 is an agreement clause.
And is Chairman AFT still, or that term is expired?
I'm sorry, my lord. This arbitrator. He's based in UK, my lord, London.
No, we'll have an arbitrator here.
We are suggested, I am only bringing notice, but we have suggested at page 71 in that arbitration notice, we suggested name of an arbitrator. I leave it to Lordship.
The service is complete. Bearing in mind the arbitration agreement between the parties, Mr. Devashish Bharuka, Learned Senior Counsel, is appointed as sole arbitrator for the Arbitration and Conciliation Act 1996. So the petition is accordingly disposed of. International arbitration.
So happy for the respondent. In fact, this matter has been settled. The company has issued a notice certificate to us on 25th of May.
The dispute between the parties
to be withdrawn.
Has been settled. Learned Counsel appearing on behalf of the petitioner, therefore seeks permission to withdraw the petition. Petition is dismissed as withdrawn.
So grateful.
The petitioner, as well as I have instructions to state that we want to settle this matter if the matter may be referred to mediation.
We'll appoint an arbitrator now and you can settle it in arbitration.
There are 10, then I have
both
objections.
parties have submitted to arbitration. They've appointed their arbitrator after the petition has been filed.
There in this matter, the notice invoking arbitration itself is not on record, my lords. They say that arbitration was invoked on 8th March 2022. That notice itself is not there, my lords. That's number one, my lords. Number two is, my lords, kindly see their prayer. Because the prayer is at page number 16.
To appoint Mr. So-and-so District Judge, Judicial Member, NCLT.
My lords, that is their own nominee, my lords.
We are not going to allow that prayer. We'll appoint an arbitrator.
My submission is, my lords, that can be referred to mediation. We'll first try to attempt for mediation.
We'll refer it to arbitration. And then you can negotiate between yourselves, try and see if, there's some resolution possible. Instead of keeping it pending, we'll dispose it off. How much is the claim actually?
$303,000.
How much does that work out to about approximately?
About 2.5 crores. It's a tribunal for 3 members. It's a 3-member tribunal. They have already appointed.
Instead of 3 members,
as per the clause.
Why don't we have one arbitrator, a sole arbitrator?
Yes.
By consent of parties, we may appoint a sole arbitrator. Because 2.5 crores, appointing 3 arbitrators, the entire amount will go in the fees of the arbitrator.
Absolutely correct.
Right?
My lords, with respect, both parties have submitted to the 3-member tribunal. Both parties have appointed their arbitrators as well.
You want 3-member tribunal?
I don't have
2.5 crores is the amount. If we appoint 3 arbitrators, the arbitrators will consume the entire amount of claim.
Let's may kindly consider one more aspect.
Bearing in mind the amount, bearing in mind the fact that bearing in mind the amount of the claim, parties have agreed to the appointment of a sole arbitrator to resolve all the claims and differences between them. We'll stop. Accordingly, acceding to the request of the Learned Counsel on behalf of the contesting parties, Mr. Nakul Diwan, Learned Senior Counsel, shall stand appointed as sole arbitrator under the Arbitration and Conciliation Act 1996. The sole arbitrator may fix his fees in consultation with the parties.
Submission may be recorded that parties are willing to settle and they may explore mediation.
Since parties are willing to explore the possibility of a mediated settlement, it would be open to them to approach the mediation center of the Supreme Court in the meantime to explore whether a settlement is possible.
Much on this submission, if the mediation could be in Hyderabad or in the High Court,
we'll do it here now.
Yes. Pleasure. Pleasure.
Resume appointment.
Any district judge in Delhi, because the sites is.
How much is the claim?
38 lakhs.
38 lakhs or crores?
38.72 lakh.
No. That's so. Whom should we appoint? To tell us.
Any retired district judge.
May I suggest, instead of going for the arbitration, may I suggest matter may be referred for the mediation? What my instructions?
Like this previous matter, we'll appoint an arbitrator. In the meantime, you go to mediation. Now tell us who should we appoint as an arbitrator?
In our letter, we have suggested one Justice Arun Arya at page 35, my listeners, retired judge.
The nature of the dispute between the parties, Miss Nina Nariman, Learned Counsel, is appointed as a sole arbitrator. 38 lakhs, we'll go send it to a junior counsel. Is appointed as an arbitrator under the Arbitration and Conciliation Act 1996. The arbitrator is requested to fix her fees in consultation with the parties. The arbitration petition is disposed of. Learned Counsel have also stated, the Learned Counsel for the contesting parties are agreed that in the meantime, they would approach the mediation center of the Supreme Court to explore the possibility for mediated settlement. Would stop. If this is not achieved within a period of on or before 31 August 2024, the arbitrator may proceed with the arbitral proceedings.
May I please, Lordships? Lordship, this is an application for appointment of sole arbitrator. The service is complete in the matter.
How much is the claim?
Reflects that.
229, 2 crores 29.
The dues are approx 2 crores 14 lakhs 72,000.
We have got a list of arbitrators of the Delhi International Arbitration Center.
Any.
Small arbitration claim, will you do it as a matter of, you can fix your fees, but we'll refer it to you. Mr. R.S. Chima, former judge of the High Court of Judicature at Bombay. Check kar lo, haan, zara.
Obligation.
Up. 29, please move.
December. What has happened to this? This is the provision of sanitary pads for girls in...
Yes, my lord. And 6 November, my lord, 2023, my lord, passed the order.
I remember that. Yes.
Lordship had passed these directions, additional directions for the union government to consider before finalizing the...
You are appearing for the union government?
I am appearing for the union.
Yes. Now, what has happened there?
Your Lordship, we have written to the states and in compliance of your Lordship's directions, we have sought all information. However, there is some information which is deficient and the policy is almost ready, but we need additional time to collect the rectified data on the ratio.
So, how long do you want?
About 8 weeks, your Lordship.
Ms. Bhatti, what is the position? Your learned junior says that the data has been collected, but there is some further work to be done.
Yes, my lords. The national policy is taking a little time, my lords. On others, we filed an affidavit, my lords, by consider having everything together, my lords. Kindly consider giving us 2 more months, my lords.
So today we are now at beginning of July.
Please,
so should we keep it early September, 31st of...
Grateful, my lords.
Ms. Aishwarya Bhatti.
In fact, my lord, some of the state like Punjab and other state is doing well, my lord. So kindly look at that policy also.
Ms. Aishwarya Bhatti, learned ASG, states that a national policy on the provision of menstrual hygiene products to school-going
adolescent girls.
For adolescent girls in schools, just adolescent girls, is under consideration, is at an advanced stage of consideration by the Union Ministry of Women and Child Development. Full stop. Learned ASG states that a consolidated policy will be prepared shortly and be placed on the record of this court within 2 months. We accordingly list these proceedings on. We'll keep it on a particular date on a Monday in the first week of September.
Very grateful, madam.
My lord, regarding the toilet also, my lord, girls' toilet.
We filed an affidavit on the ratio, but lordship may consider everything together.
Together
my lord said consider all this in the policy itself.
All right.
Great.
Item 30.
Please, Lord. Now, what is to be done here?
Well, in this matter, I beg to appear on behalf of the respondent. I am aware of the remit of 11. This is a peculiar case where Miss Elizabeth Kerker was suffering from dementia and thereafter by Alzheimer's. This is what we have said is she was of unsound mind and was not capable of contracting at all. The Vidya Trollia principle where lordships have sort of distinguished between section 11, 12 of the Contract Act as opposed to the contracts which are voidable. That's my really defense. And
that's a matter to be argued.
But here, my lord, would be a case where, my lord, she's of unsound mind.
Whether she was of unsound mind,
that will be, my lord, of course, subject to medical, my lord's records, which we have placed on record. I am also, my lord, handicapped because, my lord, the residence where she used to stay, my lord, has been, my lord, taken over by Yes Bank. I am not even able to access, my lord, my house, my lord, her belongings, etc. So, my lord, I am communicating with Yes Bank to at least permit me, my lord's inspection.
Who are now you are the legal heirs?
Yeah, I am the legal heir. My lord, I appear on behalf of a husband and, my lord, her two children, my lord, Ajit and Urshila.
We'll appoint an arbitrator, and you can ask, having regard to the claim, we'll not appoint a former judge or something. We're appointing members of our own court, of our own bar, as arbitrators in these smaller.
I don't know, the claim maybe.
The claim is around 4.5 crores in
4.5 crores.
In 19, so around 5.5 today.
So my contention may be recorded, my lord.
Yeah, that's real.
So that she's of unsound mind. But otherwise, my lord, your Vidya Trolli, my lord, make carve out that distinction, my lord.
Bearing in mind the presence of the arbitration, the existence of an arbitration agreement, this court in the exercise of its jurisdiction under Section 11 of the Arbitration Act 1996 would have to appoint an arbitrator. Would stop. The defense of the respondents, who are the heirs of Miss Elizabeth Kerkar, that she was not in full possession of her faculties when she signed the agreement, is a matter which will have to be decided by the arbitral tribunal. Would stop. We accordingly appoint Mr. Shadan Farasat, learned counsel practicing before counsel, as sole arbitrator under the Arbitration and Conciliation Act 1996. Would stop. The arbitrator may fix his fees in consultation with the parties. The arbitration petition is disposed.
May I request that issue be treated as a preliminary issue, because
that we can argue there.
All right. Obliged.
May I mention a fresh matter in item 31, a lot of members I have mentioned. There is a petition filed by 56 students from Gujarat. We are opposing any prayer for cancellation for the reason that the preconditions. So it may be tagged, my lord. I have the diary number. My lord, may take
Just keep the diary number, give it to the court master.
We'll issue notice, my lord.
All right. Now, we are nearing 1. Now, tell us broadly. We'll come back after lunch. Now, just tell us broadly. We can't hear all counsel here. We'll have to hear representative counsel.
Item 1, which is the original item which this honorable court was pleased to issue notice that writ petition was entertained. At that stage, my lord, because the facts were not very clear, so this honorable court refrained from passing an interim order. If I can just sum up the matter, my lord, in mind.
Now, which is the first? Are you on the first in the group of NEET matters?
That's fine. Item 31.
I said,
item 31.
31, 1 is mine. 31, 1 is mine. Second case is mine.
31.9 is mine, sir.
I am in 31.4 and I have filed an application for withdrawal of my writ petition.
NTA has filed reply.
Let's, in 5 of the cases,
we'll come back after lunch. Now, tell us on behalf of the petitioners, who will be making the main arguments?
Lord,
Mr. Huda is appearing.
I'm in the first case.
Mr. Matthew is appearing.
Yes.
Then,
I am appearing in item 31.4. Liz, I have filed an application for withdrawal of the same, Millards. I have instructions. Very well, Millards. Very well.
got the point, Pravina. We got the point. We'll allow you to withdraw your petition. No difficulty.
32 is a little different.
My lord, 31.9 is different. In fact, here the entire sheet has been
Appearing in one of
changed.
the petitioners?
Yes, my lord.
I'm appearing.
You are saying don't have a retest.
That's right. So I'm one of the petitioners, but not that side.
Right.
That side.
So we will first hear those counsel for the petitioners, a few of them. We don't have to hear everybody because you decide between yourselves, because we have to see light at the end of the day, who are asking for a retest. Because they are challenging the entirety of the test, saying that the contention of those who urge that the entire test stands vitiated.
Yes, madam.
We will hear them first.
Sir.
You are in that sense on the side of the respondents. You are saying that let there be no retest in the entirety for 23 lakh students. After hearing them, we will hear the NTA and the government. Mr. Kaushik is appearing for the...
I'm appearing for the NTA and Learned Solicitor General is appearing for the government of...
All right.
So I appear in 31.6.
Now,
my case is slightly different.
just one second. If we start doing this process, everybody will say I'm appearing in 40.
Lord, in 31.16, Lord, I appear for the... My case is slightly different. At my examination center, two of the centers in Meghalaya, the students were not given the papers in time, and there was a time lag of 40 minutes to 1 hour. On same strength,
it was 1563.
Yes, Lord, like 1563, but we were not given opportunity. 1563 were given opportunity
For a retest.
For a retest, but we were not given.
You are aware of the facts of Meghalaya, right?
We will file, within 2 days, we will file our response also. According to us, the data shows that there was no time lapse and they did not suffer any assignment.
All right. We got the point. We got the point. Now,
My lordship.
1 second. 1 second. Don't talk out of turn. 1 second. Don't talk out of turn. That's not the way to conduct proceedings in the Supreme Court. We will start at 2 o'clock. We will hear the counsel for the petitioners. Then we will hear individuals who have slightly different nuanced positions. We will hear everybody. There's no difficulty. Correct. Right? So we'll start first hearing those people who argue that the entire test is vitiated and have a complete retest. Because that's the broadest argument. So we'll hear first the broadest argument. Then we will see people who say that why confine it to only 1563? 1563 can't be the whole universe. There were other people who are similarly circumstanced. We'll deal with those issues also.
Not this at all.
Because
my exam has not been this is
you are actually, in that sense, you will be supported by the respondents who said don't hear the retest.
42.6 is for the PG exam for which the test is yet to be held on 11th of August.
So PG will detag.
Because that's what I was requesting it.
42.6 we will detag and hear it separately.
Please.
Mobilize.
We'll come back at 2 o'clock.
Highly appreciated.
Right.
Before we start NEET, we have just some one bail matter. We'll just finish that so that, and then we'll take it up. Just 34 is somebody here. If somebody is here, then we'll start NEET, of course. Seal number क्या है? 34. Somebody is appearing 34. And you're appearing for the petitioner or respondent?
The respondent lost, this respondent state.
Give bail here.
No, it's 9,000.
Charges been framed?
Well, charges been framed.
He's been in jail since 16 November 22.
Well, but it's more than commercial quantities, it's 9,000.
9,000 bottles of fencidal syrup.
Well, commercial quantity is one liter.
Yes, 5th August 23. I think the petitioner. Appearance लिखना है तो लिख लो नहीं तो The petitioner has been denied bail in connection with FIR number 252, which put at details yellow, dated 16 November 22, lodged at PS District Shidawad. Full stop. Charges, full stop. The allegation is that the petitioner was the owner of the truck, right? He's the owner of the truck, right, ma'am?
Yes, ma'am.
He's the owner of the a truck, which was alleged to be used for the transport of 9,075 bottles of fencidal. Full stop. The petitioner is in custody since 5 August 2023. Full stop. How many witnesses are there? What is the progress?
22 witnesses are there.
Though charges have been framed, the prosecution proposes to examine 22 witnesses. Full stop. Considering the above facts and circumstances, an early conclusion of the trial does not seem possible. Full stop. Hence, conscious as we are of the provisions of Section 37 of the NDPS Act, we have the view that the petitioner should be released on bail, subject to such terms and conditions as may be imposed by the trial court. Full stop. Accordingly, the petitioner is directed to be released on bail, subject to such terms and conditions as may be imposed by the Sessions Court. ऊपर charges have been framed, ना? वो synopsis से ले लो, sections क्या है? We'll dispose it on. Yes, Mr. Shankar.
For the petitioner, I'm sorry, I just noticed this board.
Division bench has remanded the matter back to the single judge.
The problem is the division bench overlooks the fact that this is provisional release, which your lordships have directed in a series of matters. All the other I'm surprised that only from this one matter in Kolkata did the customs file an appeal. There are more than 200 cases from Telangana and Madras where no appeals have been filed, provisional releases have been ordered. It's 97 second-hand Xerox machines. That's all it is. I don't understand the reason why they are getting into it. In any case, it's only provisional, Lords. That's all I'm seeking. Just let it be released so I can utilize it. The other orders, my lords, of your lordships, one is at page 46. I'm sorry, I think the it should be page 43, page 43. The second one, which is dated 11th August 21, my lords, at page 125, photocopiers. In each of these, your lordships have directed the release. And these are not prohibited goods. The exemption notification specifically says that if there are goods which are over 80
the High Court has relied on its own judgment.
Relied on its own judgment. That judgment has not been challenged. That judgment says, if your lordship sees.
No, the division bench, relied on its own appeal judgment, saying.
On its own judgment.
And remanded the matter.
Correct. In which at para 3, which is extracted para 3 at page 2, this sentence comes. Thus, the legal issue involved in the case has to be considered before directing provisional release of the goods. But that's putting cart before the horse. You provisionally release it subject to conditions and then decide the legal issue. That's what your lordships have done in case after case.
We'll issue notice. We'll issue notice to the union. Come back after 2 weeks.
Very well.
Issue notice returnable on liberty to serve the central agency in addition.
I'm grateful.
What are the conditions on which the single judge released the goods? Bank guarantee or deposit or what is this?
Two conditions. One is that the additional customs duty would be paid by us. The second is that 10% of the total price, there's a bank guarantee that we would have taken. That 10% is in fact not a condition imposed by the Madras High Court, Telangana, your lordships, etc. But we are willing to pay that as well.
Yes.
I'm grateful.
Item 14.
Has service been completed?
I appear for the petitioner in item 40, my lord.
Because I appear for the respondent, my lords.
Mr. Behram Kamden, should we appoint an arbitrator here?
Because I'll tell my lords my objections, my lords. Here, if you see respondents number 2 and 3, my lords, they are individuals and they have not signed the arbitration agreement at all. They are just directors of respondent 2 was a director of respondent number 1. So they cannot be dragged into this arbitration in my respectful submission.
The arbitration agreement is between the petitioner and the first respondent.
Yes, my lords. That is the case. I have some points on that also, but I understand my lords may say that because according to us, my lords, this agreement was a dead letter.
If the parties to the arbitration agreement are the petitioner and the first respondent, what is the first respondent? Is it it's an LLC?
It's an LLC.
Yes, it's a company in Dubai, my lords.
May I interject, my lord? My lord, we have been served with certain counter affidavits.
Shareholders of R1, my lords. R1 is the corporate entity. It's an LLC. The arbitration agreement is only between the applicant.
You are for the?
For R3, my lord. I'm also a shareholder like R2 is.
So you are saying that, well, you're only a shareholder. There's no question of impleading you.
I haven't consented to the arbitration agreement. I haven't signed up to the arbitration agreement.
Who's for the petitioner, Mr. Navdeep?
My lord, I am appearing for the petitioner. We were served with counter affidavits of behalf of respondent 1, 2, and 3 yesterday. I seek to file a rejoinder on those points. I'm not sure if
why should we can appoint an arbitrator as between you and the first respondent.
My lord, the issue is that the impleadment of the second and the third respondent is important for us. If the arbitrator can consider those points, then well and good. Otherwise, we wish to place a rejoinder on facts because we will be relying on the principle of alter ego and non-consensual.
Why don't we do this? One second. Why don't we do this? We can refer it to arbitration and give you liberty to move the arbitrator for deletion. That you're not. You can raise an objection under section 6.
I'm not.
Please, my lord, that would be completely.
The only basis on which I've been impleaded is I'm a shareholder. If that is the basis, then the whole.
That's the only basis.
That's the only basis. Kindly see page 282, That's the only basis in the notice of arbitration, paragraph 29.
2.5. The arbitration agreement.
The arbitration, the agreement is at page 32.
We are not parties.
The parties, my lords, are only the petitioner before your lordships and respondent number 1. The arbitration clause, my lord, is at page 39. And it's only between the two of them.
So we'll appoint an arbitrator. We'll say we'll appoint a sole arbitrator instead of having it's a claim of about 5.
My lord, then may I place the rejoinder on record then? Because my point is, my lord, that certain actions that have been committed by the shareholder as an alter ego of the company, those actions will impede the shareholders into the agreement as well. Now, my lord, these actions are very, not just the shareholder, this was a person who had incorporated the company on the basis of certain representations and then stolen some data through some mischief. My lord, these are very serious actions, and perhaps if impediment is allowed and liberty can be given for deletion, then well and okay. Otherwise, I would require some liberty to place some facts on record on a rejoinder.
Well, as I am strongly opposing, my lords, my being made a party either. That is respondent number 2. Lords, because they have an awards. For this is a counterblast. And the whole idea is to harass the individuals. That is why this is the main purport, and which is why my learned friend is insisting on it. Their main claim, my lords, they have no case. Their case is it's a name licensing agreement. Admittedly, that name was never used by me. I am not arguing all this because worse comes to worse. As far as first respondent is concerned, I don't mind. This is a frivolous application, but I will go to arbitration. But as far as respondents 2 and 3 are concerned,
the arbitration agreement admittedly is between the petitioner and the first respondent. Stop. The arbitration clause in the agreement is not in dispute. Stop. Parties have agreed that a sole arbitrator may be appointed having regard to the nature of the claims and disputes. Stop. We accordingly allow the arbitration. We accordingly direct.
Because the seat is Mumbai, my lord. So maybe have somebody from Mumbai.
Lord, I please humbly request if some time can be given to file a rejoinder. There are some serious facts that would need to be put on the record. I have received the counter.
All right. It's a counter was given to him yesterday. We'll keep it on Monday. You file your counter by Monday.
Please.
On Monday. No problem.
May it please your lordship. Lord, I'm appearing in item 31.
Lord, in 31.2.
Lord, may I pass on a very brief list of dates? Allow me to pass over this list of dates, my lord. And Lord, instead of taking my lord to the documents first, if I can.
Certainly after Mr. Huda will. Yes, would you like to?
Lord, may I first summarize, my lord, the whole issue in my own words.
Let's read your list of dates, so we'll have some idea on how to what your in 2 minutes. It's just a 2-page list of dates.
Correct,
let's read it.
Correct. Lord, in the prayer, we are seeking cancellation of this examination, which has been held on 5th of May 2024. Originally, my lord, 9th of February, this NTA had issued online applications for this examination, and as per this communication, the result was to be declared on 14th of June 2024, whereas they declared the result 4th of June 2024. So they preponed it for what reasons that I don't know. But in February 24, they said result on 14th of June. 3rd of April, there is one private counseling entity called College Kaka. They sent an email to NTA that there are people who are claiming that this OMR scam is happening, whereby certain scamsters had solicited filling up of OMR sheet on behalf of desired beneficiary candidate after the conduct of NEET exam. Lord, this mail is on record, Lord. I have placed it on record. 3rd of April, exam was 5-5. Ultimately, this scam happened, Lord, which is admitted part.
What is the first date? You said NTA issued an online application form for the NEET UG.
Correct.
On 9th February, confirming the date of declaration of result on the NTA website as 14 June.
Correct.
So results were to be declared on 14 June.
That's what they said on 9th February.
Then comes this email. Then what is 4th of April?
Lord, 4th of April is the leak of exam, because exam is, this is unauthorized release of NEET question paper has been, Lord, it's 4th of May, Lord. I'm sorry, Lord. Lord, kindly correct. Just a day before the exam, Lord, there was a Telegram channel. Lord, we have that video also, probably that need to be given to CBI. On 4th of May, a Telegram channel on the mobile app disclosed that this is the question paper and these are the answers, which have been found by the Bihar police.
Yeah.
Then, Lord, 5th is the exam. Then, Lord, on the same day, on 5/5/2024, on the same day, NTA issued a press release dated so-and-so acknowledging the issue of incorrect distribution of questions paper, which resulted in a significant loss of time for the candidates at one examination center only, that is Girls Higher Secondary Model School, Mandir, so-and-so town, Savai Madhopur, Rajasthan. The NTA assured that except this at one center, the examination commenced smoothly and peacefully at all other examination centers across the country. It's relevant to note that the NTA conducted exam of those students on the very same day by giving extra time. But this is one instance. Explain it here. There are two set of questions papers are prepared by NTA. One was the alternative, which was to be used in a contingency, was to be kept in Canara Bank. The one which was to be used was to be kept in SBI. Here what happened? They distributed the question paper by taking it from Canara Bank. And then they realized that no, this is not the question paper to be used. So they took that paper back, question paper back, gave it to again, which was taken from the SBI. This led to loss of time. So it is NTA's case that the same day it was deducted. So there was loss of time. And we held the examination again the same day for 120 students. This is how they deal with it. Then next, various instances of NEET UGC 2024 paper leak reported, and the first information report of FIR number so-and-so is lodged at Shastri Nagar, Patna, Bihar under 407 so-and-so by the Patna police.
Yes.
But 10th of May, the Economic and Cybercrime Division Bihar has released a press note dated so-and-so. In the said note, the Economic and Cybercrime Division Bihar Police has informed it has taken over the investigation from the Bihar Police after considering the prima facie evidence of pre-planned involvement of organized gang in this case. 17th of May, against the incident of paper leak, the present writ petition was filed and notice was issued. 4th of June 2024, after the NTA declared the result of NEET UG 24, on 4th of June 2024, that is 10 days prior to the scheduled date of announcement of result, that is 14th of June 2024, in a hasty manner immediately after issuing the final answer key, it is highly suspicious and the said result that 67 candidates scored 720 marks out of a maximum of 720, that is 100% marks in a highly competitive examination, and achieved a conjoint All India rank of 1 out of these 67 candidates. 6 are from the same center. Apart from the said NTA awarded irregular marks, that is 718 and 719 to the candidate, which is mathematically not possible. Allow me to explain here. But it is for the first time at the bottom. I have also given a table on the next page of this chart. The table indicates that in 2020, there was only one candidate who could secure 100% marks, that is 720 out of 720. In 21, there were 3 candidates. 22, there was one candidate. 23, there were 2 candidates. This time, for the first time in history, 67 candidates got 100% marks. It has never happened earlier. More surprisingly, but I will take Miller to the result declared.
Now, out of these 67, how many candidates were the beneficiaries of the award of the grace marks?
6. No one. 6 candidates. I'm sorry.
Because what happened was, it appears from what your list of dates says, 1563 candidates belong to those centers where wrong question paper set was handed over.
No, Miller, no. In fact, what happens is, that was only Savai Madhopur. Their case of NTAs, that there were only 100.
Just 1 second. Let us have factual clarity. Is it correct to say that 1563 candidates were belonging to those centers where the wrong set of the question paper was tendered?
One place in. So far as Savai Madhopur was initially some gaps in the account of that. This was withdrawn rates, and subsequently the exam period was extended, and all of them had exam. The minutes period that was lost by them.
So the question at Savai Madhopur, the incorrect question paper was withdrawn. The correct
fresh papers were given, and
Suppose, my lord, I get a wrong paper. By the time half an hour has gone, and the examiner realized that it is a wrong paper. But the system is, there are 2 sets of question papers.
I know that, yes.
They are not
said. One was with the SBI, one was kept with the Canada Bank.
But it's not a contingent, with a view to give that surprise element even to the examiners. That it can be Canada Bank, it can be State Bank, either of them. So wrongly one question paper was distributed, which, say for example, took half an hour. So thereafter, my lord, half an hour was extended in some cases, or 3 hours were given.
For Savai Madhopur, so the students were given their full time and the correct question paper was handed over. So the problem arose, the 1563 pertained to 2 centers, one in Haryana and one is Chhattisgarh.
They were given extra time by the minutes.
They were not, and therefore initially a decision was taken to give them grace marks. Thereafter you got representations. Once those representations were made, a grievance redressal committee was set up, and that decided to hold a fresh exam for these 1563 candidates. That Justice Vikramnath's division bench, the bench in the holidays said, let the examination be held.
6 candidates were the top rankers, which got reduced to 1. But the difference with regard to the other also is of a few marks. 7.
So in the 1563, there were 6 candidates who got 720 out of 720.
The grace marks earlier, not after.
Right. Not after the retest.
After the test, it got reduced to 1, but the remaining 5 also were in the range of around.
If I can just point out whatever is falling from the other. Now they say out for.
But now you are saying that a retest is required.
Correct.
What is the material on the basis of which you seek a retest? What is the basis?
Let me straight away. Hold on. Let me straight away address that issue. The 3 judgments by this honorable court, we all have read, which lay down the criteria and the parameters on which re-examination can be held. One authored by my lord, and the other Tanvi Sarwal, and there is another judgment from Tamil Nadu. All 3 judgments, my lord, the ratio is, if ultimately it is found that the fault was at a systemic level. One, if the integrity of the examination has been compromised. Three, if the beneficiaries of the machination of the fraud cannot be identified and segregated from the untainted.
The fault at the systemic level,
If it is at
integrity
a
of the
system
exam.
level, if the identity of the beneficiaries of the machination, the fraud, cannot be identified and segregated from the untainted. If this is a situation, then this honorable court has specifically said we will not allow one candidate who has gotten into the system through unfair means. And we will order for re-examination. That is Tanvi Sarwal, a very detailed judgment, where this honorable court found that we have identified 44. That was pre-medical and pre-dental examination, Tanvi Sarwal. This honorable court said.
So according to you now, the identification of the beneficiaries of the fraud and the identification of the untainted from the tainted is not possible. And therefore hold a retest. That's your argument.
Why I say so?
Yes.
I have primarily two documents. One is the Bihar Police press note, which says, I want to read that note, and their counter affidavit. Bihar Police says that the fault because the NTA has not followed the standard SOPs. And the scam, in a way, it is saying that the fault is at a systemic level. And it is at a large scale. NTA in the reply says two things. I'll read that relevant part.
Yes.
NTA says that as of now, we are not sure and we cannot say whether the fault is at the systemic level or not. And also, we do not want to say anything on this, whether it is at a systemic level and what is the sweep of the entire fraud, whether it is confined to 2-3 states or it has gone across the country. Because the matter is under investigation by the CBI. So, for us, it is not possible to say as on today whether the scam is at a systemic level or not. At the same time, in one paragraph, they say, it appears that all this has happened at a minuscule level. They are saying both things. Now, my lord, once NTA's positive stand is, as of now, we can't say that whether it is at a systemic level or not. Because this honorable court, to allow this examination to be sustained, I envisage a finding that yes, there is a possibility of identifying the tainted from the untainted. Fraud is not at a systemic level, and hence let the exam be sustained. At least NTA is not assisting this honorable court to reach that conclusion. They say CBI is investigating into the matter. There are 6 FIRs registered in Patna, Delhi, Rajasthan, Gujarat, Maharashtra, Jharkhand. There is a 6 FIRs registered at different levels. Now the CBI is investigating it.
So Patna, Delhi, Gujarat, Rajasthan, Jharkhand and Maharashtra.
We've tried to compile, Malutz, may I hand over a little list? I have a 1-page list of the FIRs, then I just hand it over.
Now, allow me to refer to because to begin with, it was
Now we take it that the fact that there was a leak of the question paper is an admitted fact.
That's right. Well, that's what they say. And well, I will just straight away to clinch the issue.
At one place in Patna,
All India.
Well, they say one place. Let me read
I
their
saw the
response.
report, at one place where the persons are arrested and the students who were beneficiaries were identified and their results are withheld. We'll come to the details.
I will read their
One more
response.
thing, Lord.
They were initially
Their own press release in Savai Madhopur. There another thing was in Savai.
One second, we hear one person at a time.
Let me, first, Lord, may kindly, Lord, I have placed certain documents by way of an IA in my this petition, that IA number 14.
Which is your petition number? First, what is
the first petition, Lord, writ petition number 335.
Number?
In this, Lord, there is an IA.
In the additional diary.
141267. This is page 292 of this IA. Is the Economic Enforcement Unit Bihar press release, 23rd of June 2024. Has it page 292? First para, I'll not read the entire. First para simply notices FIR has been registered, 13 people have been arrested. Para 2, the second bullet point. On the basis of, or I read the whole.
Yes.
On the first page, just second bullet point and third bullet point I want to read. First, but simply notices 13 people have been arrested. FIR has been registered. On the basis of information received in technical and scientific research, 2 additional accused who are the main conspirators of the question paper leak at Learn Boys Hostel and Play School located at so-and-so have been arrested, one of whom was hiding along with some suspects in a farmhouse in Devipur police station area in so-and-so Jharkhand. Name of the arrested accused is Baldev Singh alias Chintu, who is associated with the habitual offender of question paper leak scandal, Sanjeev Kumar alias so-and-so. Based on the available evidence, the solved question paper NEET UG 2024 exam held on so-and-so were received on mobile by this gang. Well, may kindly mark this. So it was being circulated on a mobile form. And as I said, it is on a telegram. And we have a video which was being circulated on 4th of May. According to the investigation, the arrest of accused Baldev Kumar alias Chindu had received PDF file of the sold question paper on his mobile in the morning of 5th May. Printouts were taken out from the Wi-Fi printer kept in the school and groups of candidates were made to memorize them. So Bihar police is talking of groups of candidates, not 10 candidates or 15 candidates. Now, allow me to skip the next page and page 294, just 2 paragraphs at page 294.
Yes.
294, my lord, the first paragraph. The chain of custody of question papers is being verified. That's what I say at a systemic level. And statements of employees of concerned examination center, SBI Bank branch, and Office of Blue Dot Company have been recorded. Analysis of the prescribed scrutiny standards related to examination provided by NTA, which also includes standards of transportation, storage, handover, takeover of the question paper, revealed that these have not been fully complied with by the concerned, due to which tampering with question paper boxes envelopes could not be detected. Through the thorough investigation is being done regarding at what level and at what time the exact leakage breach has occurred in the entire chain of custody. So, my lord, it is at this level when this investigation was going on.
Are there 6 or 13?
Six. At least 6.
Formulate your point that, look, the entire credibility of the examination is lost.
Correct.
It is not possible to bifurcate the tainted from the untainted candidate.
That's right.
And therefore hold the examination.
That is my concern.
What is the factual foundation for that argument?
Twofold. One, the investigation, the report, the press note I have read, this is the investigation by the Bihar police, which registered the first FIR with regard to paper leak. And they were on the spot. They started investigating. They found there is a paper leak. And they found that the SOPs were not upheld, complied with. And they were still trying to find out that at what stage and from what source the paper has been leaked. And they indicated the fault at a systemic level. Now, another supporting fact comes from NTA's reply straight away.
No. First, we are focusing on this, the press note of the Bihar Economic Offences Wing.
Pardon?
But the Bihar, this that you read out.
Correct.
What part of it shows that, well, this is really a malaise which has affected the entire examination?
May I answer, my lord?
One second, we'll hear you. Please let him complete.
This report, as per my understanding, indicates they have found that the standard SOPs which were laid down by NTA for transportation of question papers, etc., was not fully complied with. They found it as a matter of fact that the paper has been leaked. They found it as a matter of fact that it was being, the sold question paper was received by this gang on mobile phone on the morning of 5th of May.
Where do we get that?
Yes, Milord, it is there. Let me come back, Milord, to at page 292 of my second paragraph, Milord. Yes, Milord, this. The second paragraph at page 292, allow me to read that. That says it was received on mobile phone by this gang.
When were they received?
They say 5th of May 2024 in the morning. And the students were made in groups, were made to memorize the answers to these questions. This is what the finding is. As a matter of fact, we have a video which was shown to me. It's a Telegram channel where it has been recorded, which is on 4th of May. The question paper and answers were being circulated on a Telegram channel. This has been captured, the date and the Telegram channel we have. And the questions have been matched with the same question.
When were the question papers lodged in the locker?
That they will be able to tell you.
When were the question papers sent to the locker?
Uh, 5-6 days prior to the actual.
Specific date. And second, when were they pulled out of the locker? Two lockers, right? State Bank of India and Can Bank.
Banks, yes.
Now, when were they pulled out of the locker?
On the date of the exam, that is on 5th minutes.
It's not only the date which is relevant, the time.
In fact, it's the lady with regard of the reference.
What time was the examination held?
5th minutes.
What time was it held?
2 in the afternoon. 2 o'clock to 5:20. 3 hours, 20 minutes.
PS.
Now, what time were they pulled out of the locker on the 5th?
Around minutes 10:30, 11 o'clock.
Now, at how many centers in India was the exam conducted?
In India, 4,750 minutes.
4,750 centers. How many? Right. How many cities?
550.
Now, please give us specific.
571 and 15 centers were abroad minutes.
571 cities.
Yes, minutes.
And how many centers abroad?
14 minutes. 14 cities. 14 cities. Centers.
Now tell us, how many students appeared totally?
24 lakhs around minutes. Around 24 minutes.
You have the precise figure?
23 lakhs, 73 lakhs. I'll give you lordships in the
23 lakhs?
33,297. Period against registration of 24 lakhs and plus. 72,000 students, my lords, did not take the exam, despite registration.
Now, how were the papers distributed abroad?
They were sent minutes. And
when were they sent abroad?
Through the embassies minutes.
And how were they sent to the embassies?
We'll get the details minutes.
Were they sent by the diplomatic bag? Were they sent by courier?
I'll find out minutes and later.
And
based on record.
And second, if the now they were the exam was held in as many as 4,750 centers.
Yes, please.
In 571 cities.
Yes, please.
Right?
Yes.
Now, when you say that the two booklets, we'll call them,
Yes.
A and B, set A and set B.
Yes.
They were sent to these cities. When were they sent to these cities?
Yes, please.
When were they sent to these
Approximately about 5.
cities? We don't want to approximate. Tell us the precise dates.
I'll get the exact dates.
When were they and how were they sent to those cities?
Yes, please. I'll get the dates.
Bihar Police and were they lodged in the State Bank and Canara Bank in each of these cities, or what happened?
Each of the cities minutes, they are lodged with the custodians who are minutes Canara Bank and State Bank.
So we want to know on what date were the question papers sent? Where were they? When were they? When the question papers were prepared?
Yes, minutes.
Right. Question papers are prepared by one person or more than one person.
Group of experts. Question papers are prepared at the headquarters.
Where are the headquarters? Delhi.
In Delhi.
So two sets are prepared by two different groups or one group?
By the same group.
One second.
The same group of experts prepares two different sets of question papers.
At the headquarters?
Yes, please.
After they are prepared, they are given to the NTA?
Yes, please.
Right. Now, tell us when did the group of persons conduct the, prepare the question papers and give you the question papers?
Dates. I'll get the date.
Right. We want to know what was the date on which these question papers were prepared and given to you.
Yes,
Point
please.
one.
Yes, please.
After they were received by NTA, in what custody they were preserved? When did NTA send them to the State Bank of India and Canara Bank into different cities?
In between, printing is there, minutes.
Right.
Printing presses.
So when
are they sent to the printing press?
Which is the printing press?
Yes, minutes. We will get the details.
We want to know which is the printing press.
Yes,
when did you send these question papers to the printing press?
Yes, minutes.
What were the transportation arrangements made for sending them to the printing press?
Yes, minutes.
When did the printing press, after the printing press prints them, you are now talking of 24 lakhs, 50 lakh sets.
Yes.
Right? Because 24 lakh had, how many sets were printed?
Correct.
And after they were printed, where were they sent? Are they sent back to the headquarters at Delhi?
Yes, please.
Huh?
The remaining sheets,
No.
unutilized ones.
No. After the question paper is set, it is sent for printing.
Yes.
You have a printing press A.
Yes.
You need not tell us where the printing press is. Otherwise, next year they will go to that printing press.
It's there.
Now, it is sent to that printing press.
Yes, please.
Right? How is it sent to the printing press? Under what custody?
Yes.
Second, after they are printed, how does the printing press send it back to NTA? Between that date and give us that date, how many days had elapsed between that and the distribution of the question papers to these 471 cities and 4,750 centers?
The entire movement plates I'll prepare a track.
Right.
Starting from the preparation of the question paper.
See, I'll tell you why we are asking.
I'll follow.
If we come to the conclusion that the time lag between the leak and the actual date of the examination is relatively limited,
yes,
then that would be a circumstance which would militate against holding a retest.
Lodge.
If the time lag between the leak and the actual examination, Brother Mishram actually mentioned,
is wide, then
is wider, then there's a greater chance that the malaise is across the system.
Correct. I get it, minutes, I'll get the time.
If it appears that the question papers were leaked on the morning of the 5th, exam was scheduled at 2 o'clock, students were made to memorize the questions, that may be one indicator that the leak was not as widespread.
Lodge.
Somebody who has the question paper is not going to ask students to sit down and memorize them and give on the spot memorize them. How many answers can a student memorize?
There are two aspects to it.
Therefore, we have to have some clarity on facts for us to understand whether this is so systemic that we must order a retest. See, there are 2 or 3 considerations which weigh. One, if the sanctity of the examination has been lost, then a retest has to be ordered, right?
Yeah.
If we are not able to identify students who are candidates who are guilty of wrongdoing, a retest has to be ordered. If you can't distinguish the grain from the chaff, that is the tainted from the untainted, a retest has to be ordered.
Your Lordship, judgment.
On the other hand, right? On the other hand, we are dealing with now a situation of 23 lakh students. It may be far-fetched for us to at least presume, unless they point out material to us, that all 23 lakh students or a substantial number of them are involved in the fraud. For what we know, a large number of students may be just honest students who have appeared for the exam.
Large number are honest.
Large number.
Therefore, we have to see if, second, what was the modality? One more very important aspect.
Yes,
What was the modality in which the leak was detected? If the leak took place, if the modality of the leak is through electronic means, social media, then there is a possibility that the leak is extremely wide.
Well, that is the point. What your lordship said is all correct.
Just 1 second.
They leak was through the electronic media.
Matthew, 1 second.
Answer this, please.
We are flagging these issues. We want you to therefore give us a comprehensive analysis of dates.
Certainly.
Because if the leak is taking place through, say, Telegram, if it is taken through WhatsApp,
that happened.
Because if it's through social media or any electronic means of communication, then it spreads like wildfire.
Yes.
On the other hand, we must also balance it out about the time at which the leak takes place. If it's more or less in the morning of the 5th, then the time between when the leak takes place and the students have to go for the examination is very limited.
On the time.
This is a hard decision, but there is no choice.
One more thing in which we will require some assistance from both sides. Please don't treat it as an adversarial litigation. For the reason that whatever view we ultimately take, this view is impacting the lives of 23 lakh students. Second, we want to understand, is it possible for the court to identify red flags? Right? So, can we identify, either we do it or we appoint an expert committee to identify the red flags? I'll give you some examples of red flags. 720 out of 720. All right, everybody out of who gets 720 is not a fraudster. There may be still people who are extraordinarily bright in that 720 out of 720. But we found that for the previous years, the proportion was very low. Now, this year, suddenly it goes up to 67. How many out of those 720 are people from that 1563 who are beneficiaries of the added grace mark?
We have given the details in our counter affidavit.
No.
81 places.
No, we just want you to now put it down on a piece of paper for us. Second, we want to understand this. So, a change in centers is possible, right? A change in centers is possible. Suppose a student, I was just telling my brothers at lunch, suppose a student is registered at Lucknow. Suddenly you find that student has gone from Lucknow to a distant center in UP and gets the 720.
Yes.
Suppose somebody is registered at Ahmedabad and suddenly goes to a fairly distant.
Yes.
So that may be one example.
Consider, yes.
So we can, we will have to do some, if we have to separate the grain from the chaff, we will have to identify certain red flags. That those who fall in that red flag category, we may have to then hold a limited retest for that category alone. Second, is it possible to do, using the cyber forensic unit of, say, the Ministry of Home Affairs or whatever, is it possible to do a data analytics on the entire result and to identify? Now, there may be one category I was thinking, when we were reflecting on this matter, students who get exceptionally high marks in the NEET, but whose performance is not reflected in the 12th. But there again, I'll tell you one thing. 1 second. There again, there's a problem. Students don't study as hard for the 12th as they study for the NEET.
Only one figure may assist your lordship.
Another red flag.
Your lordship may
Another red flag.
assist it.
A student gets exceptionally high marks in one faculty of science, like say physics or chemistry, but gets 5 marks in the others. So, because it may be unlikely that a student who is doing so brilliantly in one would not have studied at all for the other faculty. So the only point is that, I'm not sure whether we should be doing this or whether these...
But they have not declared the entire result also.
But, may I give one?
As Brother Mishra says, does the full marks have a pattern? We also
I wanted to answer that.
We also want to understand. We also want to understand the pattern of NEET itself.
Well, it's the pattern quickly.
Well, only a
40
minute.
45 questions on physics, 45 questions on chemistry, 45 on zoology and botany. Totally 180. 4 marks.
So 45 questions on physics.
45 on chemistry, 45 on math, on botany, and 45 on zoology.
So 45 times are 4, that is
180. 180 into 4, 720.
Right.
If you get a wrong answer, -1. So therefore, if you had given 179 right answers, your score would have been 720 minus 5, that is 715. Here, there have been answers, scores of 718, 719, which is mathematically impossible. Because you lose 4.
Answer was, my lord, that it is because of the grace marks. My lord,
No, this is prior to retest. Give me 2 minutes, my lord. Give me 2 minutes.
Submission something.
One second. We'll hear you.
Just some figures which are handy, and that might answer, my lord. I'm obliged, my lord, your lordship's question. It's a very pertinent question. We examined the pattern of 100 top ranking students, those who were in the first 100. My lord, the analysis comes that they were distributed amongst 95 centers in 56 cities in 18 states or union territories. Top 100.
The top 100.
They are, my lord, found that they appeared in 95 centers located in 56 cities, which are spread out in 18 states or union territories.
And my lord.
Just one second. Now,
page 86 of my reply, page 37 is the
now, one more thing which we want to know now is that how many FIRs matter has been handed over to CBI for investigation.
I'll just tell you.
Totally, how many FIRs have been registered?
One FIR was paper leak in Patna. Rest, my lord, are FIRs for some local malpractice, my lord.
How many totally FIRs have been registered?
According to them, 6. Our knowledge is not 6.
Can you give us tomorrow, maybe
or day after, a day more, but we'll be able to.
I have a rough sheet.
Just one second. All right.
I may tell you.
Second, we want to know now. One thing is very clear that the leak has taken place
in yes, in one center.
Whether one center that's what we have to decide.
We will have to.
The fact that the sanctity of the examination is now compromised is beyond doubt.
Correct.
That there has been a leak.
Yes.
I'm sorry, madam.
Now, question is, Mr. Solicitor, how widespread is that breach?
Patna also, the paper leak is not an admitted fact. But my learned friend relied upon that press not kind of a thing.
No, it is an admitted fact. This is stated in the affidavit.
One second. But can we deny the fact that a leak of question papers took place?
Yes, my lord. Yes, my lord. The
complete cover of it is admitted in the FIR.
Bihar police, on that very day on which, my lord, some news reporting came, which my learned friend, my lord, Mr. Huda read. Lord, we issued this press that this is false. This is not our briefing to the media.
No, but is the case of NTA today that there is no leak?
It's
not. Leak is admitted.
The fact
it is admitted in their counter affidavit.
Mr. Solicitor, Mr. Kaushik, we take it that it's an admitted fact that there is a leak. Yes. There is no question about it. But, the nature of the leak is what we are determining.
Yes.
Therefore, we are asking questions. The fact that there was a leakage of question papers cannot be disputed. Now, what is the consequence of that leak would depend upon the extensive nature of that leak. If it
was
not
a contained leak or uncontained?
I'll tell you one thing. You don't cancel a whole examination merely because 2 students have committed a malpractice. Likewise, assuming that there is a leak, we don't live in an ideal world. There should be no leak. But before we decide to order a retest, we must be careful about what is the nature of that leak? Because we are conscious of the fact that we are dealing with the careers of 23 lakhs.
Absolutely right. Absolutely right.
Page 108 of
And
the
asking 23 lakh students to reappear for an examination, together with the preparation, cost, travel, and dislocation of admission schedules.
Unfortunately, there is no other choice.
I'll also take.
Unfortunately, there is no other choice. Paper has been leaked.
Now, therefore, we want to know this. Therefore, we would like to know first the entire process which took place.
Certain.
Two, what is the nature of the FIRs which have come forth? How was the leak? What is the point of time at which the leak took place? How was the leak disseminated? These are important questions. And next, very important, what are the actions which the Government of India and NTA have taken to identify the wrongdoing students or the beneficiaries of the wrongdoing?
Correct.
None.
May I say?
No, now I give an example.
I appear for someone who has come first.
I'd like to make submission.
Sir, I had.
I'm in 31.9, my lord.
No, we have understood your lordship's question. They are very pertinent question, and that would ultimately lead. But I'll just give an example.
One second, Mr. Solicitor. We also want to know what are the steps which have been taken by the NTA and by the government to identify the beneficiaries of the leaks, because that we have to be ruthless on identifying the beneficiaries.
We also have to be ruthless,
right? Because anybody who has breached the examination is not entitled to be there as a successful student.
Those who are identified, their results are. But give me an example.
How many? We want to know. How many have been identified?
Yes.
But more than how many have been identified, we want to know what was the course of action which was taken by the government.
Lord, kindly allow me to give an example. Lord, for the time being, leave Bihar. I'll not call the police also. I'll not take instructions. Take, for example, Godhra. Godhra incident, my lord, it passes on as a paper leak case. It's not a paper leak case. What happened was, there was one superintendent of one particular center called Jai Jalaram School. His name is Tushar Bhatt. Lord, he arranged with certain students that he didn't have the paper. But he said that whatever answers you can confidently answer, you give the answers. These are multiple choice questions with negative marking. And therefore, I would have a window of 3 hours before, after I take your papers back and I seal it and send it to the concerned authority. Fortunately, the authorities, the district magistrate came to know about this. It must have percolated from somewhere. Therefore, the moment examination started, the entire district administration and entire police administration was there. The papers after the examination were taken in their custody, sealed in their presence and sent, and that man was arrested. Now, from his mobile, there were several video chats which were found. And we could identify that these were the people with whom he was in touch. So those identified students, their papers are their results are with him. And they are issued show cause notices. Why should they not be?
So we want to know totally.
We are not concerned about Godhra, but what we are concerned about Patna. Patna is the leakage. Godhra, we are not complaining. I am only about paper leakage, Patna. Nothing else. All others are minor issues. Impersonation, all are minor issues. Nobody would ask for a cancel of the examination on the basis of that. only concerned about the paper leak.
Overall in the entire country,
Right.
how many students whose results have been withheld owing to what we are discussing today? Individual, one student cheating from another student, we are not bothered about that.
Absolutely.
That the law will take its own course.
Yes.
How many students are there whose results have been withheld as a result of the systemic, so we won't say systemic, as a result of the leakage which took place.
Leakage.
So, and where are those students situated? You want to see the geographical distribution of those students. Are they in one state? Are they in multiple states? Where are they situated? And third, now one more thing which we'd like to also dwell on is the following justice, the order passed by the bench presided over by Honorable Justice Vikramnath in the vacation. 1563 students, there was a retest. That was held on the 23rd of June or 21st of June. 23rd of June.
It has been withheld.
Now, one second. Just tell us for this examination now. Are we still in the process of identifying the wrongdoers in terms of the students? We're not talking of those who are perpetrators, but beneficiaries. Have we been able to completely identify the students who are the beneficiaries, or is that process still ongoing?
Answer is
no.
For instance, one second. For instance, look, if we have no go, we'll have to cancel the exam.
Right. But there has been no effort whatsoever on that side.
As a court,
yes,
this cancellation of a test of this nature, 24 lakh students,
completely agree.
Is a matter of extreme last resort. Because it may be, this
Lordship is absolutely right.
It may be, and therefore we are asking questions about what was the time at which the leakage took place. So that will give us an idea of what was the opportunity for dissemination. What is the modality?
Very pertinent.
My petition, my lord, there are 56.
Quick answer, if your lordship.
Just one second. Mr. Solicitor, one second. Sir. One second. Just one second.
Everything by day after.
1 second. One more thing I wanted to ask you is that with the kind of technology which we have today at our disposal, and the government of India has its cyber forensic unit, is it not possible for us to run through the use of experts to bring some sense of confidence to the process? That you carry out a detailed data analytics exercise to see if there are suspicious markers. Now, we have to identify what the suspicious markers are. All right. So, I just want to say one thing. Let us not be in self-denial.
Absolutely.
Right? Because, self-denial is only adding to the problems, because now everybody knows there was a leak. So, we have 2 or 3 things. We have to see what happened for this exam, what we do in the ongoing process for the conclusion of this year's admission, and finally, which is the third aspect of the matter which we'll answer, what do we do to ensure that the leak does not take place again in the future, or what are the steps we are taking to ensure that the dissemination in the future does not result in the leaks that we have encountered. On the last aspect, subject to hearing you, there should be a sort of a multidisciplinary committee consisting of the best experts, not necessarily only from the government, but people who have very wide experience and who are respected across the country. Because we are, today we are dealing, I don't have to emphasize it, we are dealing with the most prestigious of educational admissions.
And
every middle class parent,
which are the treasure.
Every middle class parents aspires their children to go to medicine or engineering, or now what are we doing to ensure that that this will not happen in future, and how are we planning to tighten the examinations process? Is there an audit being conducted by the government on what went wrong in the NTA? That's one aspect. What do we do? There's a third aspect. Second aspect, assuming that we are not going to cancel the entire exam, what do we do between today and the date of admissions to identify those who are beneficiaries of the fraud? And the first aspect, do we cancel the exam, or do we allow the counseling to go through by identifying the beneficiaries. And on the first aspect, we'd like to know from the government, what have you done so far to identify those who are beneficiaries of the...
I can assure your lordships one thing. But we are not adversary.
The report of the, yes. Report of the CBI and Patna police. That is most important, my lord. Report of the CBI and the Patna police.
Mr. Solicitor, you know, they have, from what they are trying to emphasize, we find that they place a great deal of emphasis on the fact that in the 20, 21, 22, 23, you had 1 + 3 + 1 + 2, that is 4 and 1, 5 and 2, 7 students who got 720 out of 720 in 4 years. This year, we have 67 who get 720.
Which my lord, 6 are from
One second.
We have an answer with satisfaction.
No, I have one more question. What is the percentile distribution in this exam across categories, not just 720 out of
few centers?
No. The distribution of marks, is it skewed at the top? In the last year, suppose how many were in the bottom third percentile, in the middle third percentile, in the top third percentile? This year, in the sense that will give us an indicator, was the pattern, was it a paper leak? Was the examination pattern comparatively easier as opposed to the previous year?
We have not correct. We have done the analysis. We'll place it on chart.
The chart I have given that answer my lord's query.
To make a small submission.
Last page of the 2-page note. The chart I have given that satisfies my lord's query. The marks, my lord, I have compared, given the table. My lord, somebody in 2022 who obtained 700 marks. My lord, may I kindly see this table for a moment? That will throw light on my lord's query.
222, somebody who obtained 700 marks.
Yes, in 2022, his rank was 94.
Right.
In 23, somebody 700, his rank was 247. Then somebody has 700 in 2024, his rank is 2250.
He goes down.
It goes down because there's so many people above.
Rise.
My lord, also there is another aspect.
Another question.
Also, there is another aspect.
One second. How many students appeared in 2022, 23 and 24?
Same number. See, next table is showing it. Next table is showing it, my lord. May kindly see
the 56 students that are before my lord,
total number of
all of them are stoppers.
My lord, kindly see the difference.
Lord, also,
Hold on.
my lord, also there is another aspect to it.
But the increase in a very linear fashion.
My lord, there is another aspect to it. In fact, NTA has published several answer keys. My lords, I'd like to point out. My lords, I'd like to my lord, I'd also like to point out some.
Lord, may I say something? Only one of the 56
May I be able to may I make a small submission, my lord?
Rest all of them have been meritorious, have scored highest mark in class 10 and 12. In so far as Gujarat is concerned, in these 56 people that have come before my lord. So this is a case where all of us are facing tremendous mental agony because of this.
That's all right. Now we can leave aside the emotions. You can trust us.
I'm saying that a lot of
what we want to know, Mr. Solicitor, what we want to know is this. We will have these, we'll have these anecdotal, charts like this which are given to us. Please take instructions from the government. can we not run this through a data analytics program through the cyber forensic unit? You can contact, if the government has that in the Ministry of Home Affairs, so much the better. If you don't have it, you can ask any of our top service providers to find out, because we have to identify whether the skewing of marks is so systemic that the whole examination is affected, or is it possible to identify people who are wrongdoers or likely wrongdoers, in which case a retest can be held for those students only.
I have not answered.
Lord, I'd like to make a small submission.
Not in a holistic way, but I can assure your lordships about one thing. But we are not adversarial to the petitioners either way. The petitioners who have an apprehension of an all India problem, or petitioners 23 lakhs in number plus, who are, my lord, feeling insecure because they may have to face, my lord, another examination. But we are concerned about both the sets, and we will assist your lordships, my lord, dispassionately. My lord, and whatever your lordships have suggested, my lord, I think the solution lies somewhere else. There only.
One second. What we'd like to do, insofar as the petitioners are concerned, all lawyers for the petitioners, please, we'll take it up on Wednesday. We'll give them a day's time. So solicitor also wanted 1 day's time. We'll give you a day's time to put your heads together. We want all the lawyers for the petitioners who are asking for a retest, to sit together between now and Wednesday and give us one set of submissions.
Violation.
We can't have people, 100 lawyers arguing before us on 100 different grounds. We want you to all sit down. We'll appoint one nodal counsel, as we do in the CB matters.
That's right.
You give us one consolidated submission, say not exceeding 10 pages. We don't mind, it shouldn't exceed 10 pages. Why you are pressing for a retest?
Correct.
All right?
All material we rely on for that purpose.
Likewise, we'll do this. We will ask the government to circulate a comprehensive list of dates and a response to what we have raised.
In the meantime, first this CBI can be directed, because everything is with CBI. NTA, as we have seen in the reply, they say we do not know whether it was systemic or not. Here, sometimes they completely deny there is only. So let the CBI file a status report before this honorable court in all 6 FIRs that will place the picture that in which direction the investigation is going.
Not all 6.
Not a filtration in between. Let the CBI straight away submit a status report.
Let me take instructions from.
You are appearing for the CBI also, Mr.
Let a CBI file a status report.
Why don't you do this? Ask the CBI to file a status report
on Patna. That's where the leak has occurred. All the rest of our minor issues.
On its investigation, whether it is systemic or whether it is not.
If I have submission,
more suggestion, if my lord may kindly consider it.
Lord, I'd like to make a small submission, my lord. Here, also the
Lord, there is one more suggestion. Lord, may kindly consider that.
Change in the answer also.
Lord, in the meantime.
So the order dictate kare kya abhi?
My lord,
me only one request.
Mission, my lord.
I'll call for the record from the CBI also. And because something may not be made public, how to place it before your lordships, etc. But my lord, can I request, my lord, this is a joint request, that we file everything as suggested by your lordships by Wednesday, and matter can be heard on Thursday. So we are not, my lord, nobody takes.
Investigating officer file an affidavit, my lord.
Is taken by surprise that what is the document. We'll prepare it today, file it by my lord day after. And my lord, we can have
that filtration which happens in between. But the investigating officer is the best person.
No, I'm not on CBI. On overall.
So Wednesday, he's saying take it up on Thursday.
Thursday,
Wednesday they will. So you will get 24 hours to study what they are saying.
And Lord, in the meantime, if Lord may just consider one more aspect. Only that the entire result of 23 lakh odd people be declared on their website. They have not declared that result. We will also analyze the data because they declared the result of 100 people. We could see that 6 people who secured rank 1 are from the same center.
Sir, it is declared.
No, you will be able to see.
Also,
They are not comprehensively published.
It is declared on the website.
Lord, I'd like to make a small submission.
You made your point. Let's clear Mr.
Same center, the people, student got the same marks, 720 and 720, Lordship. One center, Lordship.
From the same center,
720, 720.
Maybe allowed.
Yes.
How is it possible, Lordship? This is my question is that.
People, one center in Haryana.
Lordship, then my second question is, all our sheet is different and result is a different, Lordship. How is it possible, Lordship?
Declare the entire result. We will analyze the data that are on the resources.
Answer keys for the same OMR sheet.
Also permitted to upload above.
Multiple answer keys for one single question. It has been published by the NTA on its website.
NTA opened up on the 8th of April for enlisting students, my lords, on a 24-hour window on the 9th and the 10th of April, my lords.
And change of answer also. They have changed the answer also.
Now, this is very
They changed the answer.
Lordship, my second, and then the second question is that why the NTA has declared the result the 4th June, my lord.
My lord, there
That
are
is the question. The already, my lord.
3 answer keys for the same set of question paper. How can NTA publish that? NTA also should be investigated.
These are there. How many total?
110,000. 110,000 approximately.
Next,
Of which 50% is government.
1 lakh and plus.
How many?
108,000 something is the exact figure.
56,000 is the government seat. The entire bungling is on the government.
So that they can go to private.
And your lordship, one more data, what my lord?
My lord, I'd like to make a small submission, my lord.
My lordship, it's my humble request.
On VC.
The data which has come out, so it will be important that this please come out with complete
My lord,
PDF and OMR sheet status.
My lord, on VC, I may be allowed to make a small submission of 30 seconds.
The portal which is opened on the 9th of
9 April.
Sir, my lordship, the portal is opened on 9th April 2024. It's my humble request to please give the clear data to find out so that we can.
My lords, why the window was open on 8th and 9th? What was the reason?
2 days, sir. Only 2
And
days.
what was the result? Because this is the only difference.
My lord.
We have identified 1,506.
The candidates who are appealing.
Just we'll flag something and we'll now place it on Thursday. We'll just give some direction to the matter, so we'll be able to focus on what we want.
My matter. Notice maybe you should.
Yes, we hear you. We're not going to be.
So that we can.
On 9 February 2024, the National Testing Agency, into brackets NTA, issued an online application form for the National Eligibility cum Entrance Test, into brackets NEET UG, bracket 2024. Full stop. NTA conducted the NEET UG examination on 5 May 2024. Full stop. Results were declared on 4th June 2024. Next. On 5 May 2024, from the material which has emerged on the record at the present stage, it appears that on 5 May 2024, a first information report bearing FIR number 358/2024 was lodged at PS Shastri Nagar, Patna, alleging a leak in the NEET UG 2024 question papers implicating offences under sections 407, 408 and 409 read with section 120B of the Penal Code. Full stop. On 23 June 2024, the Economic Offences Unit of Bihar Police issued a press release noting that in connection with the above FR, 13 persons, including candidates and members of, and into inverted commas, members of the organized gang of examination leak.
Sorry, I should not interrupt. This is what I gave to your lordships. This is not true. That is what the Bihar police on that very day clarified.
Where is that clarification?
I had just given.
No, my friend is wrong.
This is what
No.
Bihar police clarified.
No, you are trying to cover up.
So this is on that very day published, my lord, by the Bihar police. This is with regard to the news report of NEET UG exam published in the Sunday Express newspaper dated 23rd June. On its front page with the headline, Bihar police put...
So this press release is not an official press release?
No, that's what the Bihar police clarified.
It's on their website.
Kindly read it further, my lord. Paper leak in my run-off and appears, my lord, for Bihar. He handed this over to me just now, my lord. In the news item, the undersigned has been wrongly quoted and the name has been mentioned at least 3 times in the news item by the correspondent so-and-so. Whereas the matter of fact is that no such brief had been given by the undersigned to him in this regard, and neither the concerned correspondent ever contacted me before attributing the quote to the undersigned. No official press release or statement in this matter had been issued. This irresponsible act of correspondent is against...
According to the petitioners, on 23 June 2024, a press release was issued by the Economic Offences Unit of the Bihar Police, setting out, in regard to the paper leak which had taken place. On the other hand, from a communication dated 23 June 2024 addressed by the Additional DGP Economic Offences Unit, it has been stated that no official press release or statement
as an act of cover-up
had been issued by the Bihar police. Full stop. Be that as it may, in this batch of petitions, one of the primary reliefs which has been sought is for a court-mandated retest of the entire process which took place, culminating in the examination which was conducted on 5 May 2024. Full stop. In support of the case, in support of their case, the petitioners have relied on two primary circumstances. First, it has been submitted that before that, you can just say the NEET UG 2024 examination consisted of multiple choice questions involving a total of 180 questions. Full stop. Each of the 180 questions carried 4 marks, making for a total of 720 marks for the examination. 45 marks each were allotted to the segments in physics,
Chemistry,
chemistry,
biology, biology,
botany,
botany and zoology.
Geology and
Botany and zoology.
physics, chemistry, botany, and zoology. Full stop. The examination envisaged the award of negative marks of one negative mark
Per wrong answer.
per wrong answer. Next. In support of the plea that the court should direct a re-examination, the petitioners have primarily relied on two circumstances. First, it has been submitted that that candidates securing the maximum of 720 marks were confined to a few students, between 2020 and 2023. In 2020, full stop. As opposed to this, in the NEET UG 2024, as many as 67 candidates are reported to have secured the maximum of 720 marks. The submission can best be highlighted by reproducing the chart which has been placed during the course of the hearing. A copy kar lijiye, haan? The above chart indicates that while one student in 2020, 3 students in 2021, 1 student in 2022, and 2 students in 2023 secured the maximum marks, there has been a radical increase in the students securing the maximum of 720 marks in 2024. Full stop. Apart from the second submission, proceeds on a comparative tabulation of the ranks which were allotted to students in 2022, 2023, and 2024.
For me, most important is the leak has happened. That is the core.
The second, the above submission is sought to be highlighted from the following tabulated chart. वो भी डाल दीजिए इसमें BB. The above chart indicates that students receiving a specific level of marks between 539 and 700 who had secured a particular rank in 2022 secured lower ranks in 2023 and a radically lower rank in 2024. No. Same marks, same level of marks. Not same student. We'll stop. Next. In considering whether, before that you can say, it is certain basic facts which are not in dispute need to be alluded to. We'll stop. About 24 lakh students registered for the NEET UG examination, which was to be conducted in the month of May 2024. We'll stop. About 23.33 lakh students, correct?
Yes, sir.
Appeared for the 23 lakhs 33,297 students. वो कौशिक जी बताइए क्या फिगर क्या है? 297 students appeared for the examination. Stop. The examination was conducted at 4750 centers comprised within 571 cities. Full stop. The examination was also held in 14 cities overseas. Full stop. The total number of seats, medical seats for undergraduate, one second, I've made a note. For undergraduate studies is 1.08 lakhs, of which approximately 56,000 are seats in government hospitals. Full stop. The investigation, prima facie, tentatively at the present stage, the court has been apprised of the fact that don't say tentatively, the court has been apprised of the fact that first information reports were registered in Patna, Delhi, Gujarat, Rajasthan, Jharkhand, and Maharashtra. Correct? Full stop. Whether the FIRs in relation to the paper leak is only confined to Patna,
yes,
or otherwise, is a matter which would have to be reserved for a more detailed elaboration, detailed consideration. Full stop. The above narration indicates that the examination was conducted over a wide spectrum comprising of nearly 23 lakh students spread over 4,750 centers in India. Full stop. Before the court can be, full stop. The law on whether a retest should be ordered in a situation such as the present is based on fairly settled parameters. Full stop. The court would have to scrutinize on the basis of the data which has emerged on the record whether, bracket 1, a breach in the sanctity of the examination has taken place, whether, bracket 1, the alleged breach has taken place at a systemic level or at a systemic level, semicolon, bracket 2, whether the breach is of a nature which has affected the integrity of the entire examinations process, and 3, whether it is possible to segregate the beneficiaries of the fraud from the untainted students. Full stop. In a situation where the breach in the sanctity of an examination affects the entirety of the process, and it is not possible to segregate those who are the beneficiaries of wrongdoing from others, it may be necessary to order a re-examination. On the other contrary wise, where the breach is confined to specific areas or centers, and it is possible to identify those who are beneficiaries of wrongdoing, it may not be appropriate to order a retest, particularly in an examination which has been conducted on such a massive scale, involving over 23 lakh students. Involving such a large body of students who would have appeared, who have studied for the examination, undertaken costs and expenses, and would have to undergo the rigors of a fresh examination if it were to be ordered by the court. Next. While flagging these issues, while flagging the above issues, we are of the view that a view on the merits would have to be deferred until further facts are placed on the record before this court. Full stop. For that purpose, we intend to direct the National Testing Agency to make a full disclosure before the court. Full stop. The disclosure which we are intending to require can broadly be classified into three aspects. The first aspect pertains to the nature of the leak, the places where the leak took place, and the lag of time between the occurrence of the leak and the conduct of the examination. From this perspective, NTA is directed to clarify on the basis of the material which is in its possession as of date on the following issues. Bracket 1. When the leak of the question papers has first taken place. 2, the manner in which the question papers were leaked, were disseminated. Semicolon, bracket 3. The duration between, the time duration between the occurrence of the leak and the actual conduct of the examination, which took place at 2 p.m., between 2 p.m. and 5:20 p.m. on 5 May 2024. The second, while making the full stop, on the above aspect, we are also of the view that since the investigation has been entrusted to the CBI, a status report should be filed by the investigating officer before this court, indicating the status of indicating
partner. For me, that's a core.
The status of the investigation up to date and the material which has come to light during the course of the investigation. One may when the leak was first noticed, Carlo. The investigating officer shall, in particular, indicate to this court, shall place before this court material which has been gathered during the course of the investigation, which would have a bearing on when the leak is alleged to have first taken place. and the modalities in which the leaked question papers were made available. Full stop. On the second perspective, the second aspect on which NTA shall make a disclosure before this court is in regard to the steps which have been taken so far for identification of the beneficiaries of the leak. This regard, the court should be apprised inter alia of the following, bracket 1. How many students, what were the steps which were taken by NTA to identify the centers / cities at which the leak took place, 2, the modalities followed for identifying the beneficiaries of the leak, and 3, the number of students who have so far been identified to be the beneficiaries of the leaked question papers. Okay. Likewise, the investigating officer
may say a stroke authority, because identification may not be within our.
All right. The above information, I'll clarify while editing. I'll put it so that it will be more the Ministry of Home Affairs or some other one.
But the leak will be at one place. At how many centers the leak paper has been made available? Because the leak will be in the entire system at one place.
No. We have said that dissemination also. We have said. The investigating officer shall also submit a status report bearing on the above aspects.
Yes.
Well, it's one point.
The third aspect on which it is necessary to have a further disclosure by the union government as well as by NTA. We'll say union government and NTA is whether it is possible by the union government and NTA is whether it would be is on whether
technically feasible.
Yeah, whether it would be feasible, using data analytics, either within the cyber forensic unit or any other expert agencies within or which may be employed by the government to identify cases where suspect cases will stop. For instance, these cases may involve full stop. This may be, if this is possible, the authorities shall identify before the court, identify the modalities which can be followed so as to segregate the tainted from the untainted students. Next. The third aspect on which we would require a disclosure is in regard to the modalities to be followed between the conclusion of the examination, including the retest which was held for 1563 students, and the actual commencement of the counseling process. Full stop. If an exercise is to be conducted by the NTA and by the union government so as to deduce any further beneficiaries of the question paper leakage, a considered decision at the policy level would have to be taken by the government on whether counseling should be allowed to proceed in the meantime or otherwise.
May not say that.
On the status of the counseling. Fourthly, the court is concerned about the steps which should be taken hereafter to ensure the sanctity of the of the national eligibility cum entrance test, so that such instances which have transpired during the course of the present session are not repeated in the future. In this regard, just 1 second, please. In this regard, it would be necessary for the government to consider setting up a multidisciplinary team consisting of renowned experts who command the wider confidence of the community to ensure that due measures are being taken to obviate any further breaches in the NEET in the future. Full stop. If a committee has already been set up by the government for deducing the steps to be taken for the future, full details shall be made available to the court. Full stop. The court may then consider whether the committee which has been constituted by the government should be allowed to proceed as it is, or whether the composition of the committee should be
modified.
Should be
Enhanced.
It is only
to be sufficiently enhanced to bring so as to bring together a pool of talent from diverse fields bearing not only on administration but also on domain expertise and data analytics. So,
I have only one section.
Learned Solicitor General and Mr. Kaushik, Learned Senior Counsel appearing, Solicitor General appearing for the Union of India, and Mr. Kaushik, Learned Senior Counsel appearing for the NTA, have requested the court to place the further hearing on Thursday ka date dal dijiye, so as to enable them to make their to file the material in pursuance of the above queries by 5 p.m. on Wednesday. Full stop. The affidavit shall be shared with counsel appearing on behalf of the petitioners simultaneously. The report of the investigating officer of the CBI shall also be placed on the record in the meantime.
May I be only permitted to say one aspect?
So, I'll tell you why. Let there be, the reason why we are asking for this disclosure, whatever view we ultimately take, let there be confidence in the community that
absolutely. We are not very.
Lord, I have only one.
So where your lordship's views?
The entire. Lords, can I make one? May request the copy will serve to us as well.
In view of the large number of counsel who are appearing on the side of the petitioners, we have requested that it has been agreed who will be the nodal counsel.
Whomsoever, my lord, Mr. Suvit Sharma, my lord, who is
independently sometime.
All right. Shall act as nodal counsel. Yes. All the counsel for the petitioners who are desirous of pressing their submission for a retest shall file a common set of submissions not exceeding 10 pages before the hearing takes place on Thursday ka date.
My lords, kindly allow the implementation application, my lord.
The petitioner on this side, my lord, can it be also be
time up lost?
On the petitioner on this side. So there's a fact that
you are being supported by these.
I appreciate, but I also want to get out the fact that happened in Gujarat. Here, all cases where they
Why don't you do this? Give us a short one-page note. That will be more.
Very well.
And as wherever your lordships have said petitioners, there are transfer petitions where we are essentially respondents.
It's taken for 2 days in April. People.
And this is beyond the leak, my lord. Beyond the leak also.
Yes, my lord. There is also a.
They have changed the answer also. They have changed the answer of one question and allotted the number, my lord.
Yes, my lord. In fact, it's happened in my case also, wherein there are 3 answers.
They can analyze these states who are the people who register.
Mr. Solicitor, we have not specifically in our order included the red flags. If you can just
have understood,
right. I deliberately didn't put it into our order, but you can just see whether there are some cases like that which you can identify. See, so that then
We have filed.
I'd like to place.
These have been served. Perhaps they are not given copies. The other ones who are intervening or etc.
But what we would suggest is what you give us on Thursday, and one more thing, what you give us on Thursday, make it comprehensive so that we don't have to wait through your counters and everything. We'll just look at that basically.
Hello, may I make one small request? Some of us are respondents.
We've now chalked out our roadmap. If we can, using whatever technology, common sense, and our understanding of the law, identify the wrongdoing students, we then don't have to ask 23 lakh students to again appear for the exam. If we have no other go, so of course we are there too.
Kindly allow the impleadment application.
For us to file that one page,
38.
Our diary number to be recorded.
Which is that matter? NEET matter.
My lords,
all right. Yes, there are three other matters which we have to take. Sorry.
Our diary number may be noted, so that we file the page. Our diary number may be noted.
All right. Any other fresh matters on NEET which were not on board?
Yes, Lord.
After we rise, you can give the matters numbers to the court master. He'll bring them on board.
My lords, kindly allow the impleadment application.
One more thing, Mr. Solicitor. Has everybody served their petitions on the council briefing?
But we have not received our replies, my lords.
All right, one second. The council appearing for all the petitioners, council appearing for all the petitioners, interveners, shall serve copies. On whom should we say?
Central, MK Maroria.
On Shri MK Maroria. And Mr.
VARDHMAN KAUSHIK.
And Mr. VARDHMAN KAUSHIK, counsel appearing, counsel instructing the Solicitor General and Mr. KAUSHIK, RC KAUSHIK respectively. The two counsel appearing on behalf of the two counsel, Mr. Maroria and Mr. The Union of India and the NTA shall prepare a tabulated statement indicating for each petition, tabulated statement grouping the petitions into distinct categories so as to facilitate disposal. So what you can do is those which are asking for a REET category, then individual grievances, then we'll see whether those grievances can be entertained, whether we ask you to look into it, what to do. But we'll have one tabulated chart on petitions.
Make it easier.
hello, may I just request one indulgence?
That's why we said, therefore you serve a copy on the solicitors.
They have changed answer also. The condition, they have changed answer of one question and has given the more marks to the 13,000 students.
Medical accommodation.
Problem for my ranking is concerned.
But look, this is nothing. Therefore, those petitions we may have to dealing. They are individual petitions. Those are individual petitions where you say you have a medical condition which should have been given extra time. We'll deal with it separately. It does not deal with the sanctity of the examination. That's individual students' petition.
Today's order should not be deemed to be as restricting only to the case of leak because between the...
Not at all. In fact, that's why we have finally said this.
So for the reason, my lords, on the 8th, while the exam was announced for the 5th, my lords, of May, on the 8th of April, overnight, my lords, they brought about a notification that there will be a window open for students who could not register for the exam way back on 16th of March. Now, this window that they opened, my lords, is absolutely difficult to understand.
So more students registered.
And
25,000 and
that began now.
Students, my lords, how many?
Hello, I am appearing in item. Request for 1 second of indulgence. My lords,
look, there are more students registering, etc. How can we?
No, my lords, with utmost respect, because the initial advertisement.
We'll hear you on that. We'll hear you on that.
The entire result, the entire comprehensive result should be put on the website. Right now, what's happening is individual results only are put up. So somebody has to go. So we can't.
Mr. Kaushik, the entire result, except for those which you have, we will say that these results shall not give rise to any equities or legal rights. But you must at least now upload the result.
Yes, the entire results.
The result is
comprehensive.
The
Data science can work here.
1 second.
The revised result of 1563 and the rest of the persons all has been uploaded on 30th.
No.
Individually.
But do you have uploaded?
So that is why we can't use data science. That's the problem. If they are deliberately keeping
Under wraps.
Well, this would, your lordships may take a call on that on Thursday. But there is something.
We'll apply mine carefully on.
Please, my lord. Kindly, my lord.
My lord, the NTA has also moved certain transfer applications. My lord, the NTA is.
Maybe the
Huh?
track record of the powers that you also looked at. Third.
Obliged.
42.6.
Just 1 second. Just 1 second. 35. Parmeshwar, the reason we kept your matter today was, now, we knew that we can't take it up today, but what is the scope now, this All India judges?
I appear in item 35.
Your lordship.
My IA alone has been.
Only his IA is there.
So what's happened, my lords, your lordships have put it up for compliance today. Your lordships orders for the past 2 years have not been complied with. At least 8 or 9 states have not released pension and allowance arrears, even though your lordships on multiple occasions extended the time limit for payment of those allowances. So that's not been complied.
Should we just take up on Thursday the issue of compliance?
That's right. Thursday. So that's also far as compliance is concerned.
Compliance.
On the main matter, my lords, only one substantive issue. Pension, the old pension scheme versus new pension scheme.
Okay.
That's the only substantive issue, and that because there are conflicts.
How long will we take on that?
All the submissions that are compiled and have been put in. I will take about 2-3 hours to explain the consequences of shifting from the old, and also to explain why.
We'll have to take it up on a Tuesday, I think.
We will have to argue.
Yes.
There's substantial argument from the state and.
So we'll take it up on a Tuesday. So this, what we'll do is today we'll keep your matter on Thursday, only for compliance of the payment of allowances, etc. by the state. That the union has no role.
For 124 order.
For 124 order. So we'll keep that on Thursday. We'll take up the issue of compliance.
There is an IA listed today, Millets. There is an IA listed today. There is a fresh IA listed today.
Three countries, Kerala, West Bengal, and Odisha, my lord. They have passed the circular, my lord, pointed to the my lord's order.
That's right.
That is what Parmeshwar is also arguing. No difficulty.
Today there is an IA, Millets. That's with regard to superannuation. Millets, the High Court has submitted an application before your lordships, and also the state government has given its willingness that it could be extended. It only requires your lordship's imprimatur. That could be taken up on Thursday.
Can be taken up on Thursday.
All right, just surprise us on Thursday.
Thursday.
At the fag end of the day now.
Thursday.
We'll take it up on Thursday.
Otherwise, they would be retired.
IA numbers just give. Chetan.
Yes, we'll give that.
Okay. First one never fixes time.
We'll take it up on Thursday.
Yeah, my lords, your lordship. This refers to the National Commission, your lordship.
Yes.
Thank you so much for giving time. It refers to the National Commission on Allied Healthcare Professionals. It was already notified in 2021.
And we had issued notice in this on 22nd.
Your lordship, it was issues. The notices were issued in September last year.
What has happened now?
But till now, about 19 states, parties have not even entered appearance, your lordship. And only 6 have only just filed their, 6 states have actually filed their, replies so far.
Can you give us a little tabulated chart? We can keep it on Thursday.
Can we do it on next Monday, your lordship?
Okay, we can do it. We can take it up on Monday. If you can just give us a tabulated note.
Yes.
So that which are the states which have implemented, which have not, and which are the states which have not filed reply.
Absolutely.
We'll give them one last opportunity. Or ask the chief secretaries to remain present or something like that. So they'll file their reply.
Your lordship, 3 years, it was actually done. I'll just take you 30 seconds. This was actually done primarily after the COVID pandemic, after the first wave. And we did not have a national register to know how many allied healthcare workers were there in this country. And after 3 years of passing of this legislation in the parliament, even now, it hasn't been actualized, your lordship.
All right. So we'll pass comprehensive directions on Monday next.
Thank you, lordship.
After you give us a note, you can just sort of also identify what are the proposed directions which you are seeking at this stage. So that we'll pass those directions.
Deeply obliged. Thank you. Thank you.
Your Lordship, Senior Advocate Meenakshi ma'am is appearing online.
My lords, this is the Manipur matter.
my lords, we're pleased to pass directions on 4th of December 2023 for the displaced students. Now, my lords, these are 59 students, and we are now into the next year, and we haven't been able to get admission. The learned solicitor was very kind. He said,
I beg to appear, my lords. We have found some solution to the, my lords, some of the students' grievances that came to us after your lordship's last order of 17th of May 24. But my lords, for dental, we are yet to find solution. If your lordships may call this next week, I'll file a status report on what solutions we have found for the Manipur University students. And for dental, we will come up with a proposal. It's at the final stages, my lords. Kindly call it next week.
On Monday, then we can take up what they have done.
my lords, I have a request. I have a request for my learned colleague on the other side. Certain solutions that have been suggested is like the students would study in a university like the Assam University or the Northeastern Hill University. Now, but they would take their exam from Manipur University. For many of them, it is said, we do not have courses or we do not have the equivalent subject or the syllabus in these other universities, so we cannot take you in. Or you may use our facility like a library or a lab, but we can't assist you anymore. That does not work. There are students from zoology, there are students from chemistry and other streams. Even if they have to use a laboratory.
Can we suggest this, Ms. Bhatti?
Yes.
Ms. Arora and Ms. Bhatti, if you can just meet between the two of you.
Yes, my lords, we'll do that.
Ms. Arora, if you can just indicate what the practical problems are.
Yes.
Tomorrow, if you meet, we keep it on Monday so that if Ms. Bhatti can take instructions from the Advocate General here,
yes,
they can sort it out to the extent it is possible. Otherwise, we'll issue directions on Monday.
Very well. My lords, I will meet with her, and we have also given a detailed written note. But be that as it,
right.
I'll surely
meet her tomorrow note also, so that we can then pass orders on Monday.
We will do that.
My lords, in terms of the dental students, my lords, my only request is the process can be expedited. My lords, they've been waiting since.
I think we will have a
Next session is completed. We'll complete it on Monday. We'll pass orders. If you can, just for dental students, instead of arguing orally, if you can just give us a one page, just in bullet point what the problem is. Please, becomes a little easier then, because there's so many disciplines we are dealing with. Then we'll issue directions on the spot. Give a copy of a note to Ms. Bhatti so that she can take instruction. Ms. Bhatti, just also see for the dental students what the issue is.
So our proposal is almost finalized, my lords. I'll share with my colleague before we show it to your lordships, my lords.
My lords, I'll just take 1 minute for item number 42.6. It was mentioned earlier, and my colleague agreed. I'm appealing for the petitioner, my lord, for it to be detagged. My lord, this is NEET PG matter. And my lord, I'll just take 1 minute. My lord, since 2021, students appearing for NEET PG have been filing a different petition each year. The last older petition got listed was on 11th of June, and it was held infructuous. So the exam takes over, the matter is not coming up for arguments. So my lord, that is increasing the burden of the court. Just 1 day needs to be fixed for final arguments, my lord. And in one of the earlier connected matters.
All right, 42.6, you mean it's an after notice matter?
Yes, my lord.
We filed
All right, then we'll give you an NMD probably in the month of August.
But my lord, the exam NEET PG is scheduled now, rescheduled on 11th of August. And in their reply, my lord, in which they had filed in one of the earlier connected matters, my lord, they had specifically
We'll keep it then, we'll prepone it. We'll keep it in July itself.
Yes, madam. Thanks very much.
Please, my lord, may I mention item 41.1, my lord? It is a fresh matter. It is a NEET UG matter. But my prayer is not for a retest, my lord. My OMR sheet has been tampered with. So all I am requesting is that my original OMR, which did not open on the first instance, I may be given that the permission may be given that the original
That's why we
OMR
serve your petition on the solicitor. They're preparing a tabulated chart for us so that then we can see which are the retest matters, which are not the retest matters. The other matters we'll take up one by one and dispose them off.
Your lordships, the item number 39.
It's a retest matter. All right, that day you can point it out.
Your lordships, in the item number 39, the NIT matter which was disposed of on 17th May, there's an IA pending, if that can be put on record, because the matter has been disposed, but the IA, an application for directions, has not been disposed of yet. Can I give the IA number
But the matter has been disposed of.
Yes, and we had mentioned that on 17th May as well.
What's
And
the
Your
IA?
Lordships,
How will the IA survive now?
Your Lordships, the IA was for overall students, a committee to be put up for overall all the students, because Your Lordships had mentioned every student from different stream can't keep coming in dental separately, engineering separately.
This is Manipur.
This is Manipur, Your Lordships. I can give the IA number and that can.
My lord, sir, the council for NB are saying that they've given the reply, but we haven't.
IA will have to be listed or what?
Similarly as how dental IA is being listed without the original writ petition being there, similarly the other IA can also be listed.
Just talk to Ms. Bhati and tell her what discipline this is so that then she can take instructions on it.
That has been already forwarded.